To mention my
Give all the memos.
because of a lawsuit stay order, the petitioner given the joining letter, but posting order is not issued. Four
Yes.
times they listed, but it was not raised.
Give.
2023
Give.
matter matters.
Give. Give all the memos.
This matter has become meaningful.
Yes, give.
Next.
Item number 1.
Pardon me, Lord. Item number 49 of today's list, Lord.
Okay.
Lordship, the matter was taken up the day before yesterday. It was a tender matter, and the Lordship had directed to supply copy to the opposite parties.
Yes, you have not supplied.
Yes, we have supplied, and Lordship, the matter was
Let us see.
probably.
Let us see.
Lordship, I pray that let it be taken up today, Lordship.
Let us see. That's I understood.
Lordship.
Your agony and anguish is well appreciated. Let us see.
Lordship.
That's one.
In item 1, I just want to clarify one thing.
Just 1 minute. What she's saying.
Really thorough. I want to inform this honorable court that
Yes, we heard the very, we just heard. It's really unfortunate. I believe on Monday we have seen
Yes.
him appearing before us.
Very active here. One,
And I find him a very amiable person, always smiling.
and having no stress at all. And on Saturday, he went went that stent,
Yeah.
and he's no more.
Stent was put.
yes, ma'am.
It will represent. So my friend will represent the corporation now. So I am just withdrawing my appearance and my engaging counseling.
Why the state will appear? Why?
But the MD has informed and the company secretary of the corporation has informed that there has been
Medical
a decision
corporation.
by the government that henceforth the corporation will be represented by the government councils.
Okay,
So therefore, that is the instruction.
okay.
I'm just with your lordship kind permission.
So,
The change of panel management. What sometimes there's a change of panel management.
change of panel of the state.
Of the corporation order.
So now they have scrapped the entire panel. Now the whatever is the government panel that
Only for this matter, my lord, only accommodation may be granted. I will go through the correct numbers.
these are unforeseen circumstances. One, yes, let it remain in the list.
And this panel, I only say, but my appearance.
Record his appearance, his name that submits.
New panel is formed. Let's wait till it is. Till the new panel is formed for the corporation state.
The corporation, madam, there are two things. One is that the corporation has changed the panel or have revisited the panel. Then the corporation will be that panel lawyer. It is one. Second is that the corporation now have decided not to engage any lawyer for them. The state will take care of their interests. So the state advocates will appear. So he is not there in the panel.
I have been desperately requested since morning not to appear in the case. I said I'll appear and inform the honorable court that you are no more interested to pursue the cases through me. But I have to inform because my power.
Yeah, definitely. Once you appear, it's your duty to come and inform.
Yes.
So should I write that the
one day because.
No, we have to write that.
You have that decision.
And it's nothing
Yeah.
written.
Anyhow, recusal accepted. That's
But you are party number one. You take instruction. You address this court.
same. Yes, call.
Item number 2.
Loan had taken a time to take instruction relating to payment of the APS amount.
Have you got the instructions?
I have received instruction from the officer, that is OP number 5. Here, what they say that as per the conditions stipulated in the contract, he is claiming the entire additional performance amount. But as per the contract, it has to be done annually because he has submitted 6 additional performance securities. Each valuing 0.50%. So on completion of 1 year, he is entitled for only 0.50%, whereas he has claimed for the entire additional performance security.
No. Why you will keep the additional performance security in absence of? That is the only thing is the security amount which is given to you. But it does not mean that you will utilize that amount.
It will be returned, but in a phased manner. That is what the
What
instruction says.
is the terms of the contract?
Your Lordship may kindly see page 36.
Page?
Page 36.
Okay, come to the page 36.
It was meant.
Page 36.
Yes.
Clause 8.2. For 8 is performance security deposit. Lordship may
That's an
kindly-
alternative one.
Yes.
First one is says within 15 days from the letter of the award, a performance security deposit in the same shape of NSC, term deposit receipts or such as a bank guarantee, valid till 90 days beyond the total contract period of 6 years, 6 months.
Then your Lordship may kindly see 8.2. Alternately, the contractor within 15 days of receipt of the letter of the award shall submit
Irrevocable performance security deposit in the shape of bank guarantee.
Yes.
Uh,
Non-judicial stamp paper. Or
What bank guarantee amount shall be equal to 3%
Yes. Then
of the contract price and shall be valid for 3 months over and above the total contract period.
Yes.
Now, the contract period was 6 years, 6 months.
From 8.
Yes?
Your Lordship may last four lines of that 8.2, your Lordship may kindly see. However, for this
If the
purpose-
works period gets extended, the contract performance shall be extended accordingly.
Yes.
However, for this purpose, the contractor shall be required to submit 6 numbers of 0.5, each valid for 81 months.
Each valid for 81 months, the sums shall be returned after successful completion of normal guarantee period and comprehensive AMC period annually. Then your Lordship may kindly see the next page. The other clause, that is 9.2. 9.2, the second subpart. On intimation from the tender inviting authority, the successful bidder shall submit the required amount of additional performance security in the manner as specified under clause 8 above prior to the signing of the contract agreement. It shall be returned after successful completion of 1 year normal guarantee period and AMC period. And so what they are saying that it has to be returned on since.
Now, when the contract was entered into,
3/12/2021, work order has been issued.
3/12,
2021.
so it is not, the period has not expired, sir. The period has not expired. They say they up to 6 years, 6 months if the period is, because EMC's annual maintenance contract is also continued.
Yes,
So for
but
that,
year wise they have to give. Now they have not given their
otherwise, then 1 year has expired.
44 lakhs from what is there, near about 55 lakhs.
No, 0.5, how much?
45 lakhs is the entire amount.
Oh, I understand. Now annually you have to give. So annually, how much it comes? At least one guarantee has to be released.
They are not specifically stated in the.
You'd come and tell us that at least what amount can be released. It is not that all the 6 would remain charged. It is one guarantee annually. If you want, you have to do it periodically. Why he has to approach the court for that?
They said
Glance to this instruction.
Huh?
Completion date of,
So when you have completed the contract, the work.
in the same year, my lord, it has been completed in
May kindly see that. That is a voluminous document. I have only given the instruction portion, the entire voluminous document will be clean.
Yes.
If my lord should kindly have a glance to the last page,
2024.
the paragraph.
I have written to him.
Yes. Yes.
Total additional performance security amount is 66,700,532.
Yes.
04 rupees. 66,07,532.
22 lakhs have been released.
An amount of rupees so and so only has been
Annually at
released
the
in
rate
favor of MS-OSI and annually at the rate 11.
No. Rupees 11 lakh 1,000 to 255.
The balance SPS amount of so and so only available at Jilla Parishad Subarnapur, and thereafter they have written it to the government for because he has claimed the entire.
No, sir. Then if the clause is saying that it has
They
to.
may be supplied to the instruction so that I will go through it, how
Correct.
much I will pay, I will specifically,
Correct.
because I have stated in my return.
No, let them file the affidavit in that
Yes.
sense so that
Yes,
you
ma'am.
will file your affidavit.
Yes, ma'am.
Pursuant to, sir, the matter was adjourned on 7/8/2025 on the instruction return.
The last president got directed to file an affidavit. Even though I am ready with an affidavit, but that instruction there is a state government file a counter. Let's see, tell me the para number 8. As regard to the para number 8 is concerned.
Which
the
one?
state
Counter?
government letter, yes,
Paragraph 8
of this counter 5 by the state government. Sorry, affidavit.
affidavit.
Yes.
That is flag C.
Yes.
By you are 4, 5, 4, 6 and 8.
Yes, no, that's 4, 6 and 8.
Yes. Paragraph 4 or 8, sorry.
But the instruction is provided by one of the scientists of this ministerial staff.
Oh, this is relating to the increase
Yes,
of a
height
reservoir
this-
height.
Yes. And he has
He has given the letter has been annexed.
yes, letter has been annexed.
Yes.
That was denied by the ministry officials that no such application is pending with government of India. So once again I wrote a letter that the scientist cannot clarify what sort of application is pending with the ministry. The scientist is filing affidavits. Once again I requested the ministry to give a proper application. The state is saying that the such application is pending. How can you say that a scientist can say, yes, this application is not available with us? Once again, yesterday I
It
wrote.
can't be because when the letter shows it has been given, then the
Exactly. To 2009, it may be a long back. Since then, the government of India has take up this letter to wrote a letter to the government of India. So it is a serious issue. I should get another clarification from the government. So let's say we give you another 10 days time. That's why.
what time on the prayer of matters. You'll see.
Item number 4.
My intervention is there, my lord.
Let them come
You
with
properly
the,
assist the honorable court.
for sure, we will,
The end user, my lord.
we will gladly invite your presence. Don't worry. Yes.
Item 4.
And the counter yesterday of the petition. So what time may be given to final legal?
Same. Submitted copy of the counter affidavit has been served yesterday. He pays for leave to file rejoinder. 1B, matter to appear after 1B. Yes.
Item number 5.
In this case, the petitioner had the tribal people of the area. The opposite party number 4, the OCL, and the opposite party number 5 is illegally issuing the permission to the draw of the water.
Huh?
For that area,
Illegally issuing?
to lift water to the company
Okay.
opposite party number 4 minor. In the same area,
Groundwater, that's the
Yes,
groundwater. Is there any demarcation of the orange zone, green zone, yellow zone, any of the central government's, that's a mandate, that groundwater level, then you have to identify the zone either as a red, green, and yellow.
no, my, it's not the groundwater.
No, your prayer is, sir, I read it, illegal lifting, drawal of underground water. So you're talking about an underground water. That's why I'm asking. Your prayer, you come, page 7 of your writ petition, sir.
However, though the empty water is lifted by the opposite party, the people depending on the two panchayats more than 10,000 and the cattle, they raise their grievance before the collector. And also the
Cattle have also raised grievance.
Yes, madam. Opposite
Yes.
number 4, sorry, annexure 4, page 20, and annexure 1 is pending before the collector Sundargarh Milo. And entire land, the tribal area, they exited so many times, but they are.
So what is your prayer, sir? Your prayer is that the writ in the nature of mandamus be issued directing the opposite party number 2 collector and the opposite party number 4 superintendent. I do not know, ING engineer Sundargarh irrigation such and such to stop illegal lifting, drawal of underground water from Khadan areas. Both are mentioned, sir, without the permission. This is what you say. So if there is any water which is there, if they wanted to lift that water for the purpose of mining, the mining activities cannot be done beneath the water or underwater. The water has to be extracted.
There, private land is there. Both way, they are lifting underground water and also.
But that is not your prayer, sir.
Yes, madam.
Your prayer is simply Khadan area number such and such underground water they are lifting. Now there are certain zones, sir. I have been dealing with those cases, at least hundreds and hundreds of cases there. The entire area, there is a meteorological department in India. They went and found out that what is the scenario of a groundwater level, the level. And they have identified certain zone as the red zone, green zone, and the yellow zone.
That's not on page number 30. I have given the map of the area. Page number 30. Absolutely identify the water area.
What is this? I am unable to understand the purpose of the PIL. What you are doing? What he really wanted to say?
Well, as far as the pleadings, my lord, as far as I can understand, my lord, they say that from a private person's land, my lord, water is being extracted. Well, this is not even.
He does not have even a private individual does not have any right in respect of underground water, which is a natural resource vested with the government.
Well,
So what he's saying that whether it corrodes any erosion that really comes if you take an underground water, because that is a very dangerous thing.
That is given to a company. The company is drawing water from water table. That is what is must be seen.
Really, I am unable to comprehend what he really wanted to say.
Because of the opposite party number 4.
Now, so far as the drawing of the underground water or utilization thereof is concerned, there must be a permission granted competent authority.
well,
that how much amount of water can be extracted.
The director of mines is committed rights.
No, he is not a competent authority in this regard. One has to understand that now so far as the underground waters are concerned, it is one of the very, very natural resources of life. And underground water, if there is not an adequate quantity of water there, if those are lifted, then there will be a vacuum or there will be a space created that may cause a lot of problems.
That his grievance as it appears is reflected in para 6. He says that the company which is given license to extract water, that license period is expired. So after that also he is allowed to draw the water. That is what. Are you saying this, Mr. Misra? Mr. Misra, are you comprehending what we are posing a question?
Yes, my lord.
What yes?
My lord, prior to that, they have submitted their grievance before the authority. But nobody is responding. But they are absolutely humiliated by the opposite party number 4 and 5.
Mr. Misra,
Yes, my lord.
Mr. Misra, is it your grievance that such and such company is given a license to draw the water, but now it is expired despite non-renewal or in absence of license, he could not have drawn the water?
From the side.
That is your grievance.
Yes, one thing. Another thing is that though the permission was given prior to the government permission, they are agitating. But though the tribal people, nothing also is gratified. Nobody is responding. But that is the Annex 1 and Annex 4 is the pending before Collector Sundargarh Mayor. More than 10,000 people are depending in that area. No, they are unable to cultivate, but their right for life is hampered, my lord.
Have you collected any scientific study that if this will hamper any cultivation or agriculture? Not do. Have you collected?
No, my lord.
So you are coming and beating the bush without anything. And I have seen that when you talk about the private land, whose land, they have not come forward. If they are so poor, not able to come, then you'll have to plead it that how many peoples are there, they are below the poverty line. They cannot say you are a public spirited person, you have come. PIL is not so easy that everybody comes, I have made a representation, so PIL. From where you got this notion?
The people of that area.
I am asking, if you are representing the peoples of that locality, then it is a representative character. Then order will be followed. Unless order 1 rule 8 is followed, we will not accept it as a representative suit or a representative litigation. Will not. Whose land is affected, he is not coming before us. Nor there is any pleading. Nor there is any pleading that those persons are unable to approach the court because of their financial stringencies, or they are below the poverty line. They are the illiterate persons. They are not even able to understand. So I being a public spirited person, is espousing their cause. Nothing pleaded.
I am also unable to understand
Sir,
their language.
satisfy that what should be the ingredients to be pleaded in a public interest litigation. Now I am very strict. I have closed my eyes to some extent in PIL. Now I am strict. Tell me that whether the PIL with such pleading lies. Sure.
They are lifting that area. Just I have received day after
Sir, I am again lifting of the water because it is a natural resources. Now tell me that it will have a very cascading effect on the agriculture. It will have a cascading effect on the life and the property. In a PIL, we have to consider this. What is the constitutional obligation, and these obligations is flouted by them.
Madam Myla, there they are lifting the water. In the said area, the private land is private land is existing.
So the private land means the land is owned by somebody. That private land, what do you mean? That this is land is owned by somebody, an individual or the family or something, not by the government. This is what you call it. Are they coming before us? Because they are the person who is affected by this. Who are you?
Petition number 1 is their land also. So they have.
So I will restrict that particular. This is not a PIL. Infringing my right under Article 300 capital A of the Constitution. Right to property. Then why PIL, sir?
Where is that? In this said area they are lifting, the government land is existing. And the private person petition number 1, land also is more than 10 acres of land.
Are you suggesting that every bit of the land contains the minor minerals or a minerals?
No, though that belt is.
If it is not, then it has to be, the mining activities has to be confined to an area where there is the minor minerals or a minerals. Not beyond that.
The local people are existing there, their village, everything, they are dependent on that.
What, sir, I am asking you, probably I am not very able to convey what is passing in my mind. You are always saying villager, 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 villager. But kindly consider the villagers are not above the law. Are they? Citizen of the country is bound by the law. If the law says that it has to be done in this manner, can you come forward since you are a villager? So I want to protest and will keep the law in a box. Can you? I'm just asking this. I don't know. I want a reaction from you. You show your legal right. Show that your constitutional right is how it is violated. We are ready to accept it. But show us. You have neither pleaded nor nothing of forthcoming from your petition. Simply on this basis, can we entertain the petition? We can't pass an order simply. You have said something and then pass the order. There should be a concrete evidence. There should be a complete pleading in this regard, which shows that you have accrued a right and your right is being violated. That is what you have to show. You have not done anything.
I will permitted voter file a better application.
So that is not a solution. So you have to be very clear in your mind when you draft a petition and then file it before the court. You have to be very sanguine about it. There should be an evidence that this is what it will affect this, and this really affects this constitutional right or the rights of the citizen. I am a public spirited person. I wanted to protect their constitutional right, statutory right, because they are unable to approach the court because of many factors. We appreciate. The public interest litigation, this concept, this remedy never comes from the Constitution, nor comes from any statute. It's a judge-made remedy, where we have innovatively adopted this remedy that one can come and file a public interest litigation. But there must be some pleading, sir. There should be some evidence, something you must show. Absolutely blank, nothing is there. So that is what we wanted. Do some homework before you come with the public interest litigation. That these are the materials which shows that this lifting of a groundwater will affect these parameters. And this comes within the fundamental rights or the constitutional rights of a citizen of the country, which is being infringed. We are there to pass an order, no difficulty.
My lord, my simple submission is that though the people are very illiterate and ignorant, they are only way to submit their grievance before the
Can there be an ignorance of law is used in judicial parlance? Sure.
the simple thing is that if the person will go before the authority and say, or suppose the Tahsildar,
That I understand.
they are not providing any document, what shall they do?
No, under the right to information, have you applied?
I
I am asking you, sir, under the right to information, have you applied?
Still they are not giving.
Show us that under the right to information you have applied.
Yes, madam.
Show us. And what information you sought for? Let us see. Where is the document? Sure.
I know when I
am asking you where you have pleaded and which is the annexure.
Sorry, my lord, this is not.
That sorry will not do. No pleading, no evidence. And at the bar, you are just throwing one paper after another. Is this a way the litigation should be decided? If you have those papers, why you have not pleaded and why you have not annexed?
Yes, but sorry, my lord, I am
That's the sir.
allowed to file better.
Do something. The material before the court, sir.
But probably 100 I have said, those are very distant places.
Again, but nothing though you have said, nothing has been said. I have read paragraph 10, 15, 10 or 11 paragraphs, no case made out. No pleading. The public interest litigation is not that, is a casual exercise, sir. It is something an extraordinary where somebody has to come and show. Yes, withdraw with better particulars. And kindly, because we cannot, just 1 minute, we cannot ignore that what is going on. I think if anybody wants to utilize the groundwater, I think some permissions are required under the law. You can't, nobody can of his own. If there is no regulation, if that is not regulated, there will be a chaotic situations and that will impact the ecological system.
You are representing the company.
Yes, Your Lord.
What are you doing? Have you got any permission to extract the groundwater?
Yes, Your Lord.
Where is the permission?
Your Lordship, the copy of the writ petition is not with us. But whatever we heard right now, this company has underwent CIRP in 2023. So CIRP, corporate insolvency. So resolution process, the resolution plan was approved by the Honorable NCLT on 30th of March 2023.
On the basis of the committee of creditors?
Yes, everything.
COC has approved it. Resolution professional is appointed. Resolution plan approved by the NCLT.
Yes. Resolution plan implemented also.
Implemented.
Now, since July 2023, we are in the process of revival of the entire company, wherein we are.
So there is no mining activities as of now.
No,
It is a
mining
company.
activity. Your Lordship, this is a.
Steel company.
Yes, this is a plant. This has a spun iron. This is an integrated steel plant, wherein various products are being manufactured, and therefore EPCOL has given us recommend. Whatever I have heard, I have to take instructions. But EPCOL has given its recommended drawl of water. An interim agreement was also there by the irrigation department.
Typical industrial promotion.
Yes,
Corporation of.
yes, EPCOL. And by the recommendation, the irrigation department, Sundargarh, has also executed an interim agreement. Everything is there in place. We are taking all necessary steps. It is not that we are not, since it has revived after being shut down for more than 10 years, now things are there at the adjacent, there are another various plants which are working. So we are drawing, there are many mines also when for them. So, your lordship, I can take instructions on that regard, but however, it rightly felt from your lordship that
What to do?
I don't know, amendment itself. Seeking the file better application.
Item number 6.
public.
Item 6 and last time you lost it directed plan and AG take instruction in this regard. Item 6 and receive the instruction by next week that I'll get. I'll get the instruction by next week.
Ma'am.
Only 2 days they are after the.
Yes, ma'am. Ma'am. Item number 7.
Detailed by the original. And that was intimated by the lining of the who have to speak for vehicle.
Under what provisions?
That is the allegation about transportation. In annex of the notice issued by the lining officer, just that he has stated that the authority vehicle has been detained. But by whom that has not been specified in the letter itself.
Vehicle along with whose detail?
Lordship.
What are the goods?
Goods and sand.
Sand.
Yes, lordship. In paragraph 4 of the petition.
To instruct the.
No, I am not licensing the vehicle of the petitioner. That is rented and it was used by the license.
There is a law or agreement law for this, not other than particular that. No, that will have to take inspection, but will he has only annexed the notice, which has been where he has been directed to come for compounding. To take compounding fee, that is what we shall do. And it should 2 million.
The vehicle is handed over to police.
Vehicle is now may not, but it's
Now taken custody of the police station.
Permit me to take instructions from that law. What I found from the pleadings is it was seized by the Tahsildar and then handed over to the mining officer.
You purchased the stand or you are transporting on somebody's behalf?
No, the vehicle is engaged in rented.
Are you transporting the goods on somebody's behalf or you have purchased and
No, the license is taken, the vehicle is used this for the
You are the owner of.
owner of the vehicle.
You use the vehicle on a hire basis.
Lordship.
Right.
Lordship.
So when somebody has hired the vehicle for transportation of a goods, have you received any document?
No white permission issued. No white.
Can you do it as the transporter? The right of a carrier and the obligation of the carrier, are you aware of what the carriers have? What are your obligations as a carrier?
Yes, I mean, the paragraph 4 of the my petition lordship.
I'm asking you, sir, when you are transporting a good, will you not obtain either a vehicle or any kind of a public documents, invoices, that these are the seller, these are the purchasers, the destination and all, everything?
No was there, but no invoice is there, lordship. But I am
Can you, there must be a transport bill as well.
Lordship.
Have you? You can't run it in this way without anything.
That's also deal with the methods. I mean,
And
both of
in-
August.
we have seen that.
That's
Mr. Counsel, what our query, please.
Whether the Carriers Act obligation of a carrier was taken into consideration in this judgment. At the Carriers Act now, can you bring that Carriers as well?
Relying on rule 51 or 58 would not do.
51, rule 51.
It would not do.
Yes, sir.
You just please leave the facts or answer the query.
Here,
On whose behalf are you carrying those goods or are you the owner of the goods?
no, I'm the owner of the vehicle and not the owner of the goods.
Or
I avail,
How are you carrying it?
plus I
How
avail.
could you load the mineral without being authorized?
Only the vehicle hired in the same was utilized by the licensee, and I am out of that in that source of income, I maintain my livelihood. I am I am compounding and disputing the penal amount here. And also-
How could you load the goods onto your vehicle without any authority?
The vehicle has handed over to the licensee.
Do not know. That's why I'm just giving you, drawing your attention, have some patience. Are you aware of there is a Carriage by Road Act 2007?
I will verify the technology.
The common carrier is defined under section 2A to mean a person engaged in a business of, you are claiming that you are engaged in a business of collecting, storing, forwarding, or distributing goods to be carried by a goods carriages. The vehicle is a goods carriages. Under the goods receipt or transporting for hire of a goods from place to place by a motorized transport on road. That is what you are doing.
Yes, yes. Sir.
For all persons in undiscriminatingly and includes a good booking company, contractor, agent, broker, couriers and all everything, door to door transportation of the goods and such and such. Section 8 of the Act says every consignor who loads the goods for the transportation shall execute a goods forwarding note in such form and manner which shall include a declaration about the value of the consignment and the goods of a dangerous or hazardous. That is why it is called a challan and it is called an invoice. Have you obtained, this is your obligation to have the challan with you and the invoices. Have you obtained the challan and the invoices? I am just asking.
That's
A very simple question.
That's why
I can understand the vehicle.
That's why I understood. One week after I will take instruction by the source notice, such invoice will be issued in favor of the petition.
You are not understanding. Please go through the act.
That's 1 week after I also verify the law.
I mean, caveat, one chapter will be solved.
Yes, madam.
Caveat is lost, then he has a right.
No, I have not received any caveat notice, madam.
No, there must be a litigation.
No,
Is
no
there any
litigation.
mechanism here?
No, caveat, name is there, or I have not received any notice because he has
No,
given
what is the procedure? I do not know here.
a caveat, he has
That
to.
once the caveat is lost,
Yes,
it is lost with the department,
yes, yes. Ma'am.
and a copy thereof is also sent to you.
Copy has,
At times you receive the copy.
no, he has given caveat to another. I mean, Hindustan Graphics the petitioner. He has given caveat to Hindustan Advertisement, that is another organization.
Oh.
I will give the copy, madam.
Same tender notice.
Huh?
What is the same tender notice?
That's why I have not.
That does not mean, you'll have to specify the name. You have to.
I'm giving the copy, madam. I will do. Copy is ready, I am giving.
And next.
Case registered, one new case is registered, so the camera automatically the system will check it.
You say I'm not there. The other system is that if a caveat is lost, then there is a department who maintains the register of the caveat. And the duration is of a 90 days or 60 days.
90 days.
90 days, 148A. 148. So there's the maintenance register. So after reformation, then the file has to go to a caveat department for his endorsement, whether no caveat or a caveat.
Yes.
If there is no caveat, they put a seal and put a sign that no caveat. If there is a caveat, then they write the name of the advocate. It's the caveat. And thereafter, the petition can be filed in the department, otherwise it will not be received. That is what I was just inquiring that whether this is the procedure followed or not.
Here they have sent the caveat petition notice to the Hindustan Advertising Registration. Another.
I am also open too. I have also received the reproduction.
No, otherwise I will take some decision in this regard so that at least that should streamline.
Yes.
The person should know immediately before the filing.
This case also.
The number is addressed below. Just asking whether he is aware of.
Yes, I am not aware because he has not given a notice to me.
It's not. If the department put an endorsement on the back of the file.
Yes.
That caveat is lost, it is there. Then you are aware.
Yes.
Then you'll have to serve and then file. Caveat change.
It's done.
That is after filing.
After.
That is what I'm saying. I'm talking about before filing. Before filing. Checking should be done before filing. Unless there is a endorsement, no, it will not be accepted.
Anyway, I have already given the copy, my lord.
Next week, Monday.
Yes, Monday.
Item 9.
My lord, kindly call it in the coming week, my lord. I want to engage a senior counsel. Let it be taken on the next. Yes.
Can a mandamus be issued to operate extraterritorial?
Engage the senior. Let it get in. Where?
Weeks time.
I can't tell, but I pass through. Pass through. Then come with the next.
Item 11. Yes, ma'am. Item 11, sir. Item 11, sir.
Is this?
Yes. Yes. Ma'am. Yes. Ma'am. Yes.
Your is the rejecting of the technical mistake.
Technical state. So my bid has not been rejected, madam.
It hasn't been accepted.
Right. But that's, in fact,
So you are jealous that why he.
actually it's not, is it cost was there, the lottery system was there.
I'm just asking, are you jealous?
Sir, I am not jealous. The only thing is I have been deprived because of the lottery system. But I was qualified. Yes, yes.
Tie.
So
what to do?
So here actually he should not be qualified to the technical bid. I have raised objection before and even after, immediately after. My objections were
Before
there.
means when you was shown
Immediate-
qualified in the technical, did you raise an objection? No.
Yes, there is objection.
At the stage of technical bid,
Yes, at the time of technical bid. There is objection.
is there any document?
Yes, madam. That is, if you also can you look at.
Yeah, first show me that why you wanted this bid to be rejected.
Kindly sir, turn to page. Page 240 in the after. The first one is 238, annexure 4.
This was. No date is given, or 29/7.
29/7.
That is the date when technical bid was open.
No, at that time actually technical bid was open. Technical bid was open, then they called for the financial.
No, on 29.
Yes.
Was it open on 29/7?
Yes. Yes, madam.
Or prior day to?
No, on 27.
Just.
Subjected on 31st. Yes.
Yes.
888.
31st. Correct. I didn't know this. My brother has more of hawk eyes.
Well, it is there is the date chart I have given now.
Yes, no.
31/7.
On 29/7, I filed.
Just one.
Let us see.
Look, your grievance is that he have not filled up the annexure one.
The affidavit
That
are
is
not in
48
form.
to 50.
Right.
And in the page 48, serial number 4 has not been mentioned either the name of
Yes.
the form not applicable, but in the case regarding the tender. Bill of pay such and such, such and such. Can I go to this document?
Yes, sir. It's there. It's there in the court.
Which page?
Also.
Okay.
And I just show your secret, 1, 2 clauses for it. 1, 2, then I'll take your 6 documents and first is okay.
Now move in your right direction. Yes. No, we are not disturbing.
Page 47 now.
47.
It starts at page 48, 1.4. Tender papers shall be submitted in the following manner. Last lines. Page 46, 1.4. Tender papers will be submitted in the following manner. Clause 1.6. As page 47. The bidder has to submit the tender paper, appendices, annexures with seal and signature on each and every page. The bidder in 1.7 shall read all the instructions guidelines carefully before filling up the tender and submitting the same so that there will be no ambiguity later on. All the instructions to bidder, terms and conditions given in the contract, along with these annexures and appendices shall be formed part of the agreement. That's very important one. And any violation of the provision prescribed here under shall be construed as violation of the agreement. Tender will not accompany the scheduled annexure documents detailed in checklist, appendix 2 in tag, duly filled in and signed shall be liable for rejection. Then let's kindly turn to page 54. Clause 3.3. Other terms and conditions. The bidder must furnish full, precise, correct, and accurate details of information in the tender document.
54.
3.3.
Yes, yes.
The information about bidder, the bidder must furnish full, precise, correct, and accurate detail of information asked for it in the tender document. 3.4, this is also very important in the sense. Signing of tender, person or persons signing the tender papers shall state in what capacity he or she or they are signing the tender, that is sole proprietor or a firm or a director of a limited company or a partner of a partnership firm. The name of the partners, directors will be disclosed and the tender papers shall signed by all the partners or the partner duly authorized or their duly constituted attorney, having authorized to bind the partners to all matters pertaining to the correct. Copy of the registered partnership, this is a proprietorship concern, that not necessarily. If you also kindly turn to page 65, clause 12. Evaluation. It says submission of tenders shall be deemed to have been done after careful study and examination of the tender document with full understanding of its implications. To failure to comply with the requirement of any paragraph or any clauses of the tender shall render the tender incomplete, which is liable for rejection. Authentication, signature of the tender shall be as per the provisions outlined in para 3. Para 3 I read just before of this tender document. Any interlineation, eraser, rewriting made in the scanned copy shall valid only if the paper, the person signed the tender authenticate the same with full signature. So then, now the kind return to Page 144. And these are the affidavits to be filed. This is the format annexure 5 at page 144. This he has mentioned copy attached. He has signed it below.
Yes.
Mentioned copy attached. Copy is at 188. 144 page. The affidavit has page 188.
Oh.
In the format, if your lordship looks at, he has to say whether he is a proprietor or a partner or a director. In the format, it is there. But the affidavit has not mentioned anything about it. Yes, but individual affidavit has been filed without any seal, without indicating whether he is a proprietor or a partner or anything else.
Capacity plus.
Yes, correct. 188, the affidavit is there. The same thing at page 146, identical. He has not complied with the specific directive. So they say it has very meticulously, it has to be filled up. Page 146, at page that annexure 6. Again, the same affidavit is required to be filed, either as a proprietor, partner, or a director. Page 191, the affidavit is there. The affidavit also doesn't contain whether the same has been filed by the proprietor or the director. Simply on individual capacity, an affidavit has been filed. You also may turn to a very important document, the declaration at page 148. Annexes 7A and 7B.
Another is in the name and style of business concern.
Good follow.
Did this filed in the name and style of the business
Proprietor. Someone is critical proprietor, and it has to be, he should mention that he is a proprietor.
He has filed in the name of
Proprietorship concern.
business concern.
Right. This 148, clause 7A, if your lordship looks at, this declaration says either you have to mention proprietor, director, or partner. The blanks are there. He has not filled in the blanks. This is the original. This has not been changed. He has not given in annex.
Business concern
Yes.
is not specified.
Yes.
Is there any bar that an individual cannot participate in the tender unless he is a proprietor or a director or a partner?
No, he has filled in the form as proprietor. As proprietor. But the affidavit has to be
Proprietor of himself.
himself. You're also right. But he writes the name of the proprietor's capital.
Has he used any messes, M, obliges or something before his name?
Or he has not mentioned M, nothing else. Nothing else. He had only mentioned capital name. And he signs in his normal signature. Only thing is, the authorities.
Concept of this proprietorship person.
He is mentioned as a proprietorship form.
Because the proprietorship concerns are not governed by any statute.
Right,
Partnership form is governed by a property title.
right.
Company is governed by his company's act.
Nobody's
The
right.
proprietorship concern is not governed by your. Now, under the procedure also how the proprietor has to sign
Right,
and affirm and verify everything.
right. But here the only
This is an individual because use the word is good enough.
correct word.
Use the word proprietor, you fill it.
the name of the proprietorship concern is different than the name of the proprietor.
I understand you, but my respective service is that the statute, the tender document specifically provides. Yes. He has mentioned blanks. He has kept blanks. He has not filled up.
Better on the part of the individual to participate in the.
The individuals are not restricted, but if you say that I am a proprietorship firm,
Capacity as an individual, he files, then he's not supposed to.
no, he has not filed it. But he,
Proprietor,
you say he-
director.
yes, your worship is correct, but he has not filed it in individual capacity.
Where is this document that you want to proceed by?
Yes, I'll show that. 140, page 140, that's what I can say. Exactly I wanted to show. There is also, he has mentioned wrongly self at page 140.
Yeah.
This is the only document he has mentioned
Self, yes, said so.
proprietor.
No.
Top ballot.
That's one self.
No, top ballot. Name of the bidder. Name of the bidder,
Doesn't know
Samaraspati.
what's the distinction between a proprietor and that is somebody, an individual is running a business in a compendium name.
Right.
That is one.
Right.
If the compendium name is something else than the individual, then he can. He is the same person. I think he has applied individual. He's the proprietor. He says that I am the proprietor of my body and my.
Right. He says that I am the proprietor.
Of my body and soul.
He has almost separate business, name and style, that's what I asked.
Name and style has mentioned all capital. If your worship looks at Samaraspati,
But there are signatures which are in capital.
but he has not signed capital. He has signed normal.
No, even.
If your worship looks at the bottom,
Gladfully, you gladfully must accept that fate. You are not defeated actually. You have,
sir,
because the lottery was conducted.
lottery was conducted, right?
In fate.
Sir, another, what I beg to submit another thing. Sir, kindly. And 83 has also mentioned sole proprietary. Page 183. But here, Lordship, can you see page 244 for 1 minute? If Lordship, can you look at page 144? 144, 244, I'm sorry. No, I am extremely sorry. I couldn't bring it to also notice. Justice Raman was putting a question whether it is mentioned measures. Yes, your Lordship. Page 220, madam. Page 220. Then I'll take your Lordship 244. Yes, madam. I just missed it. I'm sorry. My friend actually. He is referring to the firm as Messrs. Samaraspati. No, but he has mentioned.
Notice also.
Right, right.
That also is Messrs.
Yes.
Even if it is proprietary, then what?
He has mentioned Samaraspati.
Messrs.
Name of the organization. But as per 244 also will say how they are technically rejecting the bids of similar defects that was there in the form itself. Therefore, they have it specifically indicated in clause 3 and 3.6.
You may have some technical point. Too hyper technical in that sense, I must be saying. And when the technicalities is pitted against a social justice, then what should we do?
But if it is essential condition, a person who files an affidavit has to specifically mention whether he is filing the affidavit.
So, when the concept of proprietorship concern is concerned, I think these are one and the same picture. And they really wanted the disclosure of the name, so it's a name of the concerned reporting and the proprietor. Just to know that who is the proprietor, they wanted it. Here we can hear that we know that, but there is no distinction.
He himself has done it, but he has not followed the specification provided in the tender document. And they have
not put a Messrs. He has put the capital letter, the negative.
like only capital letter. But Messrs.
He has not, and obvious.
But he has mentioned in the registration of document.
I understand. So whether this M obvious is a above.
That-
Will have such a larger impact on him. Because I find in every signature, beneath that, he has given a capital letter of.
And they require actually it has to be sealed and signed.
Proprietorship concern sometimes.
And I am also proprietor concerned. They asked me to put a seal. I have put the seal in every
Your
case.
name is different, sir. You are running a business in your compendium.
Right.
It's not you're running in your name.
Not in my name. That's right.
That's why then how one should.
But name,
United Electricals, how do some know that who is the proprietor of the United Electricals? So name has to be given. The name are matching.
here it's a, here the name is also just a symbol itself. Like somebody has to identify somebody with a particular name.
True. Otherwise, there is no concept of giving name.
Right.
And the Shakespeare has also embraced it. So he said what is there in the name.
So, this is
If the rose is
Rose
called
is a
by
rose.
another name,
Right.
within rose is fragrance. That is one of the Shakespeare.
sexual. That's right.
But still the name has.
Here I would like to bring your attention to one thing, page 244, let's we can see. I would like to bring your attention to page that they have rejected disqualified persons who have not mentioned the page numbers.
Yeah.
Page 244.
Yes.
This Devi Prasanna Sahu.
No, he has not mentioned two numbers of the vehicle, which is very important.
No, the second, the third and fourth number. So not the top one, the second one.
Oh, they have corroborated more, that one may not be sufficient, give more ground. But this is what is important. Two numbers of vehicles, because in other cases also, we have come to.
He says that signature copy, signed copy of the corrigendum, addendum not submitted, not mentioned the number of pages in the tender paper. They are so technical. And same thing at page 246. Affidavit on use of vehicles.
Ajit, listed as 49 today.
Same, two vehicle,
Yes.
numbers for all the.
Yes.
Areas.
Absolutely.
Same basic number for all the areas are given.
See,
He obviously mentioned for one, he applied for 4 blocks.
Right.
For each block, same number of vehicles, 2. I could appreciate that different numbers of vehicles are given. But it's the same number of vehicles, which is the requirement under the tender. Massive. What he does was that in 3, he has given written.
Right.
For 1, because of the dearth of space,
Yes.
where to put it, he simply say attached. And on that ground, rejected. That you have shown 6, not 8. That is what it says. Thank you.
Civil supply corporation, last,
Who is the successful bidder? And who is for the authority? Who has floated the tender?
The civil supplies.
Who is representing civil supply?
And there, copy may be served. Yesterday matter was
Sometimes I think the ice breaks, so one goes and others are being meticulously scrutinized.
the tender has been floated by the opposite part number to the State Civil Supply Corporation, but the scrutiny is being done by the District Tender Committee headed by the Collector of the state.
Headed by the chairman. The chairman.
Alert Civil Supply Corporation, the collector and other officers are.
The tender committee, you have rejected it, you are.
Then the committee.
Of the tender committee. You are answering why you have rejected it.
Well, the committee is answering.
And why you have not rejected? I think the question is wrongly framed. Why you have not rejected? When you have rejected the other bids.
Here, the committee chairman is.
Is the collector.
Collector and chairman.
Second party, office part number 3.
3.
You represent. You are representing.
Yes, ma'am.
So.
I will take instructive.
That's the whole irony of every time only on instance.
Will it only fair?
Yes, the copy, I believe, much advanced.
So copy has been served. Only the civil supply corporations. Only copy has been given to me.
But not to them.
No, they have been given. Not to.
Now there is a office part number 3.
Yes.
We received the copy on 20th. That is the whole picture.
Copy has been given. Copy has been given to state.
Yeah.
20th.
Yesterday.
Yes, sir.
That is the whole picture.
This is started for 48 hours. Come on Monday.
I'll do that. Right.
Come on Monday.
Orders have been passed. These are the matters for non-existence of.
No, item 17 may kindly set apart. About 90, I'm so sorry.
One after the.
10th.
Why don't you correctly instruct?
Sorry, sir.
While talking to your junior. Correctly instruct.
16, 17 already orders have been passed, but since your receipt is kept pending all these matters, keeping pending.
GST.
So let these 2 matters be added with, tagged with item number 50.
Item
50 is a batch of matters of similar identical.
These 2 matters are not tagged.
Yes.
Not tagged.
Tagged.
Maybe tagged,
Right.
but orders have already been passed.
Yes.
Getting operational.
Is in process.
As per your situation, circular, review when chairperson assumes office.
That must be amended. That will be amended, I think, without amendment. Your lordship, the limitation. I'm expecting. Because without amendment, how the limitation will accrue, your lordship. So what for that?
Venice terminal office registry is getting operational.
Your lordship, instruction is in process. No definite instruction has been, only instruction.
All members are.
No, our state members have not been appointed. State admin accounting members have been appointed.
Only judicial.
Judicial members have been appointed and some of the states accounting members have been appointed.
Yes.
Item number 18. Yes.
Item 18, your lordship, is non-constitutional jurisdiction.
Yes.
Let it be also tagged with item.
Item 19.
19 minutes.
I'm sorry. Not to be part of sorting. Because what has happened in this case, perhaps, because there was proceeding initiated, minutes on 122 minutes, and 122 minutes is penalty minutes, and 130 is the constitutional proceeding. Because then for 130 proceeding minutes, 120 or 130, a so-called notice in DRC 1 was issued minutes. The reply was fine. My grievance, I have very short grievance for Archip minutes in this case. So annexure 3 or Archip will find that summary of the order, annexure the DRC 07.
Your lordship, I'm considering. Your lordship, my instruction.
I think your concession may not help unless you make a statement before my lord that the date of today handing over the copy of the order to my lord.
That is not required as per the statute. You may argue, please.
No, my submission would be that.
Yes.
Oh, why you are getting agitated? He is representing his client. You are representing the department.
Your lordship, DRC 07 has been approved.
You are disturbed because even after concession, he is arguing. So I understand. Sometimes the concession may go against him as well.
No. Answer.
So that is why he has a right.
Answer.
So what has happened? Annexure 3, if you lordship will see below for a while. That this is the probably the copy. You want the opportunity to explain the reason as to why they were mentioned goods from unaccounted shall not be confiscated. Notice we want to reply and then
Your lordship, adjudication have been done. DRC 07.
understand.
DRC 07 have been uploaded.
Yes.
Only this annexure inadvertently that has not been uploaded. Your lordship.
It should go. DRC 7 should go. The opportunity must be given.
No, opportunity has been given. Everything has been done.
No. In the above premises.
Your lordship, everything has been done. Only along with DRC 07, his allegation in the entirely, in all the paragraphs, that along with DRC 07, the annexure, the detailed order should close. His allegation. As per Rule 142, Sub-Rule 5, the summary of the order, only the rule says, the summary of the order is to be uploaded. I don't support this order. I am just, it is an inadvertent mistake that this annexure has not been uploaded. I am handing it over. It is appealable. Let him file appeal. Because the DRC 07 rightly uploaded as per your lordship, for a moment.
Let him argue.
Your lordship.
Page 27, if your lordship will see mirrors, that the DRC 7, annexure 3 mirrors. I might. 27. Yes, it starts from 26. At the bottom, at page 27, my lordship kindly see copy of the payments pending which proceeding will be initiated for recovery. No, that's lordship kindly see. Copy of the detailed order is uploaded available as separate attachment. But there is no separate attachment. Exactly. That is not there. But you say the enclosure is DRC 1. No. I don't say. I say that summary of the order itself cannot substitute the order. If you look at the order, left hand side, there is an enclosure.
Enclosure, yes. But enclosure is not there.
What are you talking?
And DRC one will not is the show cause notice.
DRC was a show cause notice. Reply was
The
filed.
detailed order has not been given.
Correct, Vilas.
So he wanted to give you a detailed order.
Correct. Now my friend probably is handing over to my lord.
Yes, only that detail.
So only what I said, probably my friend didn't understand.
I am considering
No,
that details.
that is what I am submitting.
This conclusion to be like that. Advertisement, this reasoned order would be matched and uploaded.
Correct.
While uploading only 07.
Correct.
Summary is uploaded
Correct.
without the reason. So now he's handing.
Now he's handing over the reason.
Correct.
And once the reason is given, you have a right. Your right to appeal will start from today.
That is what.
Even this is not typed.
Correct. Anyway, that is, it's a on principle.
Sir, simple thing.
Simple thing.
He is agitated. Why?
And already sent to your mail.
Hey, that is what I at the very outset said by lords that
Give him.
simple step.
Already sent to
And
your
once the 42.5 says mandates, it is uploaded. But now
Actually, what happened?
You are
It has been
handing over.
uploaded. It has been uploaded, but unfortunately, that remain in the
we treat people date of communication. That is what this is what correct.
Also same thing here.
Item 20.
Item 20, Your Lordship. So registration cancellation matter, Your Lordship, I've already submitted the covered order.
Where is the order? What was the understood 3 now? Well, it's item 20. 20 is CG Corporation. It's for 21. Hers is item 21. Oh, you are in item 21, madam, not 28.
Sorry, Your Lordship.
Then you appear,
Madam, Sam.
in 21.
Yes, I'm appealing for 20, madam. I'm appealing 20.
20 is also the cancellation.
Yes, ma'am.
You are not supposed to.
I have not appeared. Just I'm appearing in 20 because of that. When she submitted.
Yes. Give that order. There is the order of cancellation. Have you seen?
He has not
Give it.
given any
Give
order.
it to him.
I will ask him to provide.
Give it to him. Give it to him. That's order. You don't know the order.
Order is the annexed 3 He is not aware.
No, you have the brief.
Yes.
Page 3. Sorry, Annex 3.
Next 3 is a copy of the appellate order.
Order.
So he wanted that order to common order for caution. So that is what he is not having that. Give him, you correct it. Correct it.
Your cancellation is page 12.
Yes.
Mr. Kamti.
Right.
Mr. Kamti. For cancellation of registration is at annexure 1.
B3.
He has not annexed.
Cancellation of RC order is at annexure 1, page 11.
Yes, madam.
Help him. He does not know. Help him
Yes.
from the file.
So he says that order, which are at your concession, usually we pass that to be made effective, applicable to you. Right?
Right.
Ignoring first appellate order. Right?
Right.
Yes.
I supply the order, madam.
21.
Now, we will do that.
Well, it's
Item 21, Your Lordship.
rectified order and pass.
Yeah.
This is also registration cancellation matter, Your Lordship.
Huh?
Item 21, Your Lordship.
Similar order for process.
Item 22.
Suspended justice for my place with 21.
Meeting 4 relates to 73 4B of service.
Item not 23. Sorry. That you at 2 p.m. Wrongly called. Item not 24 now.
Yes.
24. Sir.
In this matter, it is looking at the order of honorable signatures. I just need your losses the brief outline. The basis of which your losses can consider that I am a manufacturer and exporter of food processing unit in the state of Orissa. And the central government came with a policy of production linked incentive. Production linked incentive. They say that if you have this, if you are certified, and if you export such and such, then you will get some 10% incentives. That's production incentive. But I was certified and I was supposed to do a matter of 137 crores was my target. But I just because I'm giving a lots of brief outline, I'm not taking to any documents right away, so that your also can understand in that background.
137 crores, and I was supposed to give a bank guarantee of 4.11 crores, which I have given. But thereafter, after that giving that lot, that there was a Ukraine war and other things, and my application was to reduce it to 82 crores. We're capable of doing that amount because of the subsequent events. Now, this application being pending, it continued. Then thereafter, Lord, the government, this central government, Lord, accepted, saying that we will give it, we will allow it to withdraw, but we will penalize you by taking the incentive of bank guarantee of 4.11 crores. That amount they will encash. That is the issue for the lordships, that whether they can encash. But I have not received a single incentive because I submit to lordships both in fact and law. But in fact, the honorable signatures has allowed parties said that not be allowed, but they will consider on the ground of force measures. That is not been totally disallowed. Part have been allowed. This part has not been allowed, and unless your lordships will to become res judicata binding on me. What they said that I have not received a single incentive from the central government. I have not received a single benefit from the central government in terms of land or anything of that sort. My was that if I do a particular target, I receive a particular incentive. And my submission to your lordships is that seeing the clauses, my your lordships would be, which the honorable senior judge did not accept, is that it is incentive linked. That means if I receive the incentive and I'm not able to do it, they have every right to take back the incentive given to me. Without giving any incentive, they cannot take it. If you lordships kindly see, Lord, in this background, Lord, kindly see the clause 5, which honorable senior judge relied but did not accept. I tell your lordships where you have not accepted. Page 90, sir. There's 90.
9.
90. This has been further explicitly clarified later. I will give the lordship that also. Page 90. If a selected applicant, you will also get it 15.1.10 clause. That's the third. If a selected applicant is found to be ineligible at any stage, or it has not complied with notification, orders, guidelines, etc., issued under the scheme, or declines to offer approval under the scheme at any stage for any reason, this is not here, incentive claim of such selected applicants have been forfeited. That means whatever I've got, will go back to them. The bank guarantees shall be invoked, following which the offer letter issued shall stand cancelled. Now, this has been more clarified, if you notice, in their approval letter itself at 145. Kindly see, sir, 145, the approval letter. That is 145. This was the approval, first approval in December, not second approval, but nothing was from that. December 3rd, 2021. Application of home means, that's the petitioner. See the bill 146, 1.2. Then, if I also got it, 10% of the incentive due of financial year 2021-22 will be deducted if you fail to complete the investment as committed. However, if at the end of financial year 2022-23, the committed investment is completed, then the amount deducted for financial year would be paid to the company. By the end of financial year 2022-23, if the committed investment is not completed, it will be considered defaulted on your committed investment, would not be eligible for receiving any further incentive. You will be liable to refund the incentive received till that time. The bank guarantees have been invoked. The question for lordships should be local fact and as well as law. I will place your lordship Raman Foundry, which is the basis of saying that you can't take something which you have not suffered. The central government has not suffered anything. I am going to suffer because my unit of 1,000 employees will be sick because nothing. I don't have the industry. I don't incentive, but I lose 4 crores. But this is your sir. This is a clause. This is 146, and your lordships thereafter your bank guarantee given. Then this is again reiterated at 155. This is reiterated in the second lordships gate 156, same thing. That if the incentive, the selected applicant liable to refund the incentive received till that time, the bank guarantee shall be broken. So the incentive received and bank guarantee are interrelated. It's not by a bank guarantee. Let's supposing not for whatever reason. Here is a case where there is court itself has found there is a force majeure clauses. If for whatever reason I'm unsuccessful partially. That doesn't mean that I should suffer double.
What is the modalities which this scheme provides? That when first thing is that you have to apply under that scheme.
Yes.
So you must have applied under that scheme.
Yes.
So now when you start making a productions meant to be exported.
Yes, but I'll humbly submit, sir. It was a non-starter from the beginning. All this happened within 3-4 months. It was a non-starter from the beginning. After this was approved, my lord, I immediately wrote a letter to them because of Ukraine war, etc.
No, that is the difference. When you applied, you may not have foreseen that there would be a Ukraine war. I understand. So now, once you applied and come under that particular scheme, then what is the obligation which is really foisted upon you under that scheme? Now the question is, you are saying that it was always an incentive link or production link, export link scheme. If I do an export of a particular field, I will be entitled to 10% incentives. In what form?
Sir.
Is a form of a refund or it is a form
extra money given to me. Then supposing, sir, I make an export of 100 rupees, then they will give me, the central government will give me 10 rupees.
So that is what is the amount.
Yes.
Not refund, but the payment.
No,
disbursement.
payment.
Let us so go by a disbursement.
Payment.
They will disburse you a 10% of the invoice value.
Invoice value. Yes, sir.
Correct?
How much?
Correct. Your case is that you have not achieved the target. You could not achieve the target. You are invoking the force majeure clause, saying that because of this unforeseen circumstances, there has been a sharp decline in purchasing my product in the European market by the European unions or whatever. They are not purchasing it. So you ask for, so far as the barrier to be decreased.
For
a barrier to be decreased. That. So they were taking into consideration, but they have not taken any decision.
They have not said anything.
According to you, whatever you have exported.
I have not exported anything. It could go through whatever investment.
I was under the impression that you exported.
No. Whatever, sir, I invest, I'll get that percentage. I have
what invest?
Invest on this for the purpose of export and manufacturing. I invest 137 crores. Invest 137 crores. I will get amount. So
you will be entitled to 13.7 crores.
You can call it as form of a subsidy.
Correct.
Lordship can consider it a form of a subsidy to me. Post investment, if I invest.
So you have invested. You invested or not invested?
It has not been invested because first I immediately said that reduce it to 82 crores. I can't invest that much of money because of Ukraine war. Then thereafter also I informed them there was a fire incident.
Whether it was after that particular application to come under that particular scheme.
I asked for reduction.
This scheme provides for any subsidized rate of the land to be allotted to you?
No scheme. As you're also right, I was checking up. There is no subsidized land, no subsidized water, no subsidized money, no loans, nothing. It is my investment. If I do my investment, if that's the reason I told you also, both in fact and law, they have done nothing for me. If I get something, sir, I do something, I get it. But here is a case I'm not able to do for other reasons. It was also not reduced where maybe I would have been capable of doing, but it was not reduced by them. I asked them to reduce by 82 crores. there was a fire incident. They said that, okay, we allow you to go, but you have to, your bank guarantee would be encash. Because they're linking a bank guarantee with performance of the my project. I am saying, sir, kindly see the clauses. It's not linked up to my performance of the project, but if my incentive taken has to be taken back by them, because if they give an incentive and I don't do it, they have every right to take it back. But here in the case, I've not a single incentive given. Your Lordship are right in that whether if I get something subsidized land, subsidized water, subsidized bank loans, any form, zero. I have not got anything from central government. If I would have done it, I would have got 10%. I couldn't do it. Now, question is, notwithstanding that, can they still penalize me with that 4 crore? 4 crores is a huge sum for it.
Which for the other side?
The central government.
Your Lordship, I have a bid for opposition 1 and 2 only.
Who is opposite party number 1 and 2?
Let's say, so, one, yeah, I'm telling you also. One are the central government who make the policy, but they have a system of a central government unit which will be the project proponent. That means he will coordinate. That is the IFCA. Central government I'm taking, but they are independent. They can.
No, notices are not issued to 3 and 4.
Nothing.
No.
It's before.
First time.
Yes. And the first part is that they accept.
This is against
state. No, it is.
This is against
Notice.
Yes. Honorable Single has one paragraph said that since you are liable to pay, since it's a scheme, that's what they say. They say that it's in fact remanded, partly allowed to the central government, saying that you consider whether it's a force majeure clause for which is to be benefit of. They possibly can consider and accept, may reject. But this is not my right. That will be their practice.
Give a notice, issue notice on that.
1 and 2.
Yes, copies I gave.
Yes.
Grateful, sir.
25.
How the 5 centers are in one village budget? Anganwadi centers were. There are 6 centers. The population was, my lord, I have got the instruction that in 2011 census, the population was 2,132, my lord. As per the guideline, government guidelines, from 400 to 800 populations, 1 center is additional to them. So now it in the 2025, if it, the population is more than doubled, my lord, near about 5,000. Therefore, 6 centers have been opened in that village, Mosundi. Here, my lord, I made the application being a resident of village Mosundi for the post of Anganwadi worker in the year 13, my lord. And I was selected, my lord, for that Mosundi Anganwadi center on the basis of the guideline under Annex 2, my lord. So, Lordship kindly have a glimpse of the guideline at page 21, my lord. If the guideline dated 25/2007 provides that the applications for selection of volunteers to work as Anganwadi workers will be invited for each village or Anganwadi center area from a woman residing in the said village and center area. My lord, this respondent number 4 also applied along with the respondent 5 and 6.
No, what you say? Sorry, I was looking at the judgment. What you say? Where it says Anganwadi work center area or village? What did it say?
Guideline 25/2027. Yes, 2007 guideline at page 21, Annex 2.
Yes, which one you are referring?
My lord, the revised guidelines for Selection of
No, where?
clause 1.
Okay, each village slash Anganwadi village.
Application for selection of volunteers to work as Anganwadi workers will be invited for each village or Anganwadi center area from a woman residing in the said village or Anganwadi center area. Either she may be of that village or that Anganwadi center area, my lord. Here the advertisement.
No, I understand. Because this, the village is one, but it is
Village is
divided into 5 or 6,
Six.
the Anganwadi center area. So that 6 Anganwadi centers have been set up in the village.
In the village.
So admittedly, you are residing in a village, but not in that particular center
area.
So your contention is that when a slash is used, so it has to be used as or. So either of the situation is contemplated. So you are admittedly the resident of the village, so you should be.
My claim was that I was residing after being separated from my father-in-law. I was residing with the center area 5 miles. My name has been registered in the center area. As a pregnant woman, I became pregnant. That was registered. I have given that document.
That was after the application.
That was not accepted.
That was after the
Selection.
application, sir.
After the application. Therefore, my lord, my contention is that no guideline has been violated. The appellate authority said that the guideline has been violated.
Why what is where is a scheme or a policy of setting up this center, more than one center within one village? What was the rationale? Because the village has not been divided. It is for the purpose of Anganwadi centers, it has been divided.
Different centers, they have got their own jurisdiction.
Territorial, why there must be a policy decision of the government that to divide it. What was the reason therefore?
Lordship, after the same question, Mr. Late Das, my lord, was appearing on the line. My lord.
Unfortunately, I can't ask.
No, my lord, that's no, my lord.
I will get that instruction. The basis for division of the village into different.
Difficult is because I find when there is a, I would say, the slash which is used. So can it be treated as disjunctive or it is treated as an alternative? That is
my submission is that it is an alternative, because this is the guideline. It says that may be invited from each village or Anganwadi center area. Why, my lord, I say this is because the ADM in his order is reflected that it was for a particular center area only, not the village. My lord can see the impugn order in the writ petition annexure 6.
No, that is what I wanted to know, that why the policy decision was taken to set up more than one Anganwadi center within one village.
Yes, my lord, may kindly allow me some time, my lord.
Why? There should be.
What is the basis for?
If the land records does not make any distinctions, can by virtue of this, a distinction may be created. He is still regarded as a resident of.
I will get the instruction.
Look, there is a reason behind it. This honorable court has already held the reasoning why service areas are there. I only have one copy of my lord. The reasoning that your lordship is asking for. I only have one copy. I'm sorry, my lords. My lord, please have paragraph 8 at page 3. The policy of the government as a rational. It is noted earlier that the Anganwadi worker is not a civil servant, rather is a volunteer. She is expected to render a very important function for providing prenatal and postnatal early childhood care service for a community. Her continuing presence in the community is essential for that reason. If a person is not a resident in the community, which is the target area of the Anganwadi center, then it may not be always possible for the volunteer to attend to the needs of the expectant mother and children. Secondly, it is noted that the Anganwadi worker is always paid as honorarium. It is not possible to her to take a house on rent in the service area of the Anganwadi center to reside there. Thus, on these two grounds, the court is of the opinion that the policy taken by the state government is correct. As already pointed out, the selection of Anganwadi worker cannot be challenged for violating Article 16 service.
No, that is a different issue. I am asking on a different line.
The rationale was
The rationale is that how then what is the distance? What we indicate for the purpose of commutation, what is the distance?
400 population, that's the.
I am again, when it is on a population basis, then I do not find on a distance basis any rationale can be seen.
That is why they say in that there is a survey report from X number of house number has been given, X house to Y house. So whatever the population.
Then there is no rationale behind it, if it on the basis of a population.
Well, the survey reports are there in the state counter. The survey reports are annexed, which
Sir, it may so happen that within a particular village, which is say within 500 meters, there is a conglomeration of several houses, and there are more than 400 people residing therein. And somebody on a peripheral of 500, his house is there, but comes within the another Anganwadi center area. Then we do not find any rationale that one who is just away 1 meter will be eligible and the one who is just 1 meter away will be ineligible. If it is on a population basis, if it is on a geographical way, you have divided it. I can understand. What is the rationale? If that is the rationale, then because the judgment is because of the commutation time. That a person must be there within the village to attend the situations every time within the community. And if the village is one and the same, then what is the difficulty?
the policy decision taken by the state people.
I understand, but then the interpretation has to be done in this way. When you call each village / Anganwadi center area, then one has to understand this. Though he claimed that he has shifted there, but the report of Lakshmi goes against you.
My lord, the report and one member has given the certificate, and I have also registered my name on that Anganwadi Center 5 area.
That is much after.
Much after. My lord, that is my residence is near about only 200 meters away from that house. My father-in-law's house.
You are having a good relation with your father-in-law?
No, they have no good relations with father-in-law.
Or no good relation?
No. So husband and wife.
That is what we gather from the
two children
document. That's why I asked this question. You are showing your residence.
They have divided. Good relations, I do not know. They have been partitioned.
Amongst the father and son.
Son, the other sons are there. They have divided themselves.
Divided. Father is still there.
Father is there.
No.
I don't know what is the relationship with the father.
Once you have already segregated yourself from your father,
father-in-law.
I mean the father-in-law, your husband, that shows relationship is so cordial.
Particularly in those areas, she's a scheduled caste lady, my lord. Particularly scheduled caste lady. Particularly in those areas, my lord, after being married, they are usually being separated from fathers.
So Western culture.
Western culture. Yes, that is there. Yes.
I think Indian culture is something different.
That culture is there. After being married, they are being separated from home. This is just like
I have not come across.
Tribal culture.
I have been associated with the community belonging to that. But I never come across that this is what the culture is.
That is good.
I think the Indian culture is more paramount. We are also following that.
Yes, since this generation, we have not been divided. We have not been divided.
We are also not. The bonding is more than anybody.
For 3 generation, we are residing in one house in my village.
Permit me some time, my lord. I'll get that the basis, my lord.
Because that is a single bench judgment, not binding on us. We have to take. This may not bind us. So, the rationale was only on the basis of a distance it was given.
They can have on their own sides.
Yes, my lord.
They will have some.
My lord, surveys have been undertaken.
With regard to operation and.
We just wanted to know the
houses
objective,
ratio.
the objective, all these kind of setting up of the different Anganwadi centers.
Houses to operations.
I have been serving for 13 years, my lord.
That's an illegally held post, my lord.
Not
Yes,
illegal,
sir.
not illegal, my lord. I have secured my.
My lord will decide.
Not illegal.
My lord, I am saying this because, my lord, right now there's a judgment against him. So that has been on 2 occasions, the ATM, learned ATM, as well as the Honorable Single Judge have categorically held in my favor. I have been illegally deprived of that post for the last 13 years, which I was entitled to. And an order was there in my favor of December
You are in
2015.
4th position.
What your husband does?
Pardon?
What your husband does?
My husband is a Delhi wager, my lord.
Yes.
First time, not my exactly 1 week time or 2 weeks time. 1 week's time will do.
10 days.
Yes,
No.
Your lordship has last option instructed government council not to terminate my service.
I mean, pardon my lord. Item 38. Item 38, sir, I'm appearing for the opposite party. It's for the petitioner there. I pray for 2 weeks, I file counter affidavit. It's for the.
Matter fixed for 2 p.m. Item number 23.
Item number 23. Because Mr. Das was the connecting counsel, Mr. Dumbisa Das. My lord, sir, where my lord,
In fact, he happens to be a brother, so he can't even argue against me. That's the
That is
reason.
the position you can't. Nobody can foresee. Very unfortunate incident has happened. Nobody can.
You're a very active person.
Oh, we saw him on probably on Monday or Tuesday.
Yes, Monday. Then Monday. Thursday was arguing.
Very sad. When who is now substituting him?
Lord, as of today, my lord, we have not, my lord, it has not been assigned to anybody. Because this happened yesterday night only.
No. He avoid.
No.
No. Who is any?
That was really given this.
Weakness. Weakness.
Not possible.
Lordship's, 1st of September at 2 p.m. because your lordship, rest of the days I will be out of station. That's why I'm just waiting for. No. 1st of September, I'm praying because then the next following week, if you're not choosing. 8th or 9th.
Absolutely, we have no.
But difficulty is there.
First, there may be some.
Yes, some problem. Yes, that we are also.
Well, actually, 2nd, 3rd, 4th, I'm actually out of station, so that's
Okay,
the only
then
reason.
eight,
And 5th is the holiday.
Ninth, my lord.
If you continue to my.
9th, at 2 p.m. you're not choosing.
Yes.
Only problem is
Difficulty.
so far is to pass.
Now, sir, I written a letter with regard to that interim.
It's nothing.
You can know what you are saying.
About 9.
My lord, what actually my lord last day, my lord was hearing this case, instructed my senior firm Mr. Das to communicate that they should not proceed further. And thereafter there is
They had,
one more.
last time I had shown that letter.
Yes, yes. One more prayer only. Well, in that case, one corrigenda was missing. We could not file it. I am filing with that document. That is a corrigenda.
Nobody is there to take.
No, on record I will sign. No, on record it will
He
come.
may not be engaged. That
Yes.
whom you will pass on the file.
Yes,
My lord.
we'll file it.
Yes, come.
Fine.
Okay. Item number 26. Passover matter, that is. Item 26.
So this matter was taken up on 13th August 2025. There on that day, lots. That was taken up from 13th August 2025.
Yes.
There also was refused to direct me to solve copy.
That's the review.
That is. But my 10 was Mrs. Misra refused to receive the copy.
Why? Who is Mr. Mushru?
Was not appeared.
A senior advocate is not supposed to receive that.
No, not senior advocate, not senior advocate. He said, and over telephone, I talked to him, he said he may engage some other counsel. So let notice go. On which Chief Justice has requested you to appear. Despite the same loss, I am taking a lawsuit to the fact of the case, little class. I humbly pray a lawsuit to come to page 77.
What is the?
That is the order passed in repetition. Silent repetition.
No, you are.
6.5 and 7.8.
Is a 6.5 order.
That is 6.5 order. Announcement can come to 215, page 215. There was his lordship made a mention that I have not placed the application.
215.
215, page 215.
215 is the order.
Page 215 was order dated 6/5/2025.
Correct. This is the order review stand disposed of as not pressed.
Yes, boss.
So,
then was I filed a petition because that review was argued for a long time and some judgments have been cited. I filed a petition that no, it has not been not pressed, but on the ground of maintainability
It was dismissed, but however, inadvertently, it has been not pressed. So I filed a petition to recall that order. That is, you automatically come to page 220. My petition, your also has gone through that petition on the last occasion.
No. First thing is that whether the appeal lies.
Then was another against my petition. Another order was passed on 7/8/7/2025.
That is on an application for recalling.
Yes, Lord.
Now tell me whether it lies.
Because there my right of appeal has been taken away by mentioning that it has not been. That's the reason why I filed a petition, interim application to get that order modified. And that has also been rejected. And on the last occasion, your lawsuit has gone through.
What modified? Order to recall.
Recall. Because by saying recall, there is a office saying that recall petition will not be entertained. That's the reason why we are filing modified petition for modification.
What modification?
That is what petition your lawsuit can prayer. Prayer page 224. Page 224.
Tell us about whether this order comes within the purview of a judgment. Because under the clause 10 of the legislature, the judgment which can be assailed, whether it comes within the purview of the judgment.
That doesn't come within the purview of the judgment.
Then how the clause 10 appeal lies?
There was that the reason was why I have filed a petition. Because I have also gone to the last time and also asked put my question that whether any response has been filed to that or not. So you also asked me for that, and I have given a lawsuit to that response. Thereafter, you also taken a view that you call him.
No, that was the difference because this now he has refused. Not whether this comes within the purview of a judgment.
You also for that reason, I will like to draw lawsuit attendance to page 77. For a moment, also can see what is the fact. I have understood. I have understood what you also want. Because once not pressed,
respond to the query of the
once the court
talks about clause 10 of the legislature, which is the source of power to file an appeal against the judgment of the single bench. To a division position. Whether it's comes within the purview of the judgment.
necessarily it is not coming within the purview of judgment, but
It's not coming within the purview of the judgment. Then whether it is committed, then you have to throw it up. The appeal is not committed.
plus in that case, the substantive right of the present petitioner, present appellant, plus goes. If an is
So there are certain provisions which say not right, right still remains. Only thing is the forum. You may not have this forum, but you may have other forum.
plus per moment. All of for appreciation, plus what has happened for which review has been prepared.
Jurisdiction at all.
I haven't.
To entertain.
I have.
That is what.
I have.
Once you do not have jurisdiction at all, there should be, what is the scope of looking at any document?
Sir, we have two orders.
Yes.
On perusal of two orders, our query is whether whether these orders comes within the purview of judgment. So far as clause 10 of the latest patent applicable to this court is concerned.
May I examine tomorrow must pass case, I will examine particular.
Please read one judgment I am giving you.
Yes.
Order upon a judgment. Babula PG's case.
What?
Of the Supreme Court.
Great process.
Kimji's case. Read that.
Yes. I'll get the judgment. I'll take it.
You read that's the I think the landmark judgment on this court.
Plus, I'll also get to the other judgments. Plus, tomorrow, why
judgment you will not find.
Okay.
That is the landmark judgment and which is still followed. Other judgment you will not be able to find. All have taken care of this KG's. Yes, that
is 1981 volume 4 SCG page 8.
Read the judgment. That's Babula Kimji.
1981 volume 4 page 8. Yes, sir.
What is the judgment which what comes within the purview of a judgment vis-a-vis the latest patent? Read.
Sahab Abdul Jaiben with Kenya.
Jaiben with Kenya.
It comes to judgment. This clause. This one, this is judgment. This time. look at it. It says very lucidly, it has been finally. The intention of our givers of the letters patent was that the word judgment would receive a much wider and more liberal interpretation than the word judgment used in the Code of Civil Procedure. At the same time, don't be happy.
No, I'm learning from Procedural. I'm grateful to laws.
You are really emboldened
No.
to add that wider connotation and given more liberal.
No, I'm learning from
At the same breath, the learned judge says, at the same time, it cannot be said that any order passed by the trial judge would amount to a judgment. Otherwise, there will be no end to the number of orders which would be applicable under the latest patent. So it seems that the word judgment has undoubtedly a concept of finality in a broader and not a narrow sense. So judgment can be of three kinds. Then here, one is the final judgment, one is the preliminary judgment, and third one is the intermediary judgment. And then he proceeded that every interlocutory orders cannot be regarded as a judgment, but only those orders will be the judgment which decide matters of the moment to affect vital and relevant rights of the parties, and which work seriously in prejudice or injustice to the parties. Similarly, the order passed by the trial judge deciding question of admissibility or relevancy of a document also cannot be treated as a judgment, because the grievance in this court can be corrected by appellate court. So there, then I'm just reading some portion. That and you just go through this judgment. It's a 3-judge bench decision. Go through it, whether this comes within the purview of those exceptions which have been laid down here.
Yes, but your also was only. This is my right.
I say that this judgment is the foundation judgment and is followed continuously till date. No departure can be seen there.
2022 is the latest followed.
But
2022 is
So go and read this judgment. Whether you come within the purview. What injustice?
Yes.
I know you have been very enlightened with this.
I'm not excited because I'm telling you the laws.
One word does not make a hell of the difference.
In a wider sense, laws, here the right of I'll go through.
You go through it.
I'll go through laws. I'm grateful to laws for providing
But
that.
there are many orders which are not applicable or coming within the purview of the judgment.
Yes.
There the remedy is not lost, but the remedy lies directly. Straight away.
That's right. That also can happen here.
You have to go there.
This is also the right formula. I'll come up tomorrow. First case, I'll take it up because this is a case where I mean
you read. Tomorrow is not a easy task. What you are saying, read the judgment and don't divorce one sentence.
No.
Benefit. Then the other sentence you ignore.
No, I will not ignore because I will convince your lordship.
When I read the first sentence, you were very happy that it comes. But I say, read the second sentence.
No, the other fifth, sixth sentence was more in my favor.
No.
Yes, first. In a wider sense, because here my right has been got rid.
Secondly, there are another aspect. The dismissal of the review is also not applicable under the Code of Civil Procedure. Remember, if you look at Order 47 of the Code of Civil Procedure,
yes.
Order 47, Rule 7. It's only when the review application is allowed, it is available, rejection, no other.
So that I did, that I filed a petition.
I say that's why I'm saying from both the corners.
Yes.
Because in Kimji, you will find the court has said that this latest pittance, the provision of an appeal, is not guided or controlled by the CPC. CPC may provide for an appeal, but the latest appeal may not, because it does not come within the purview of judge. So that's why it says. So I just said from both the aspects, then we have to say it's not.
Yes, sir. And we for tomorrow, but no, sir, before that, may
Without reading the judgment before that, don't say.
Oh my
Don't
God.
utter in air or a vacuum where you do not know that what is the judgment.
No, so
Please go through that. Do not argue in air. I
No.
understand.
grateful to us.
Come on, Monday, we are giving you a week. Biggest quarter of us.
2 p.m. in principle.
Monday,
Monday 2 Grateful.
Item number 27.
Yes. Who have not been parties before the honorable single judge. Challenge the introductory order under annexure measure 1 at page 12. The introductory order was passed, granting the final relief made in the page 12. In the read petition measure. My lord, we are the slum dwellers and enclosure. As my lord, your lordship called for a report on the last occasion to ascertain, because I have shown your lordship to that Slum Dwellers Act 2017. Lordship put a pertinent question whether any committee has been constituted, because I am relying on that certificate given.
No, first thing, sir, you are a slum, because their allegation was that there is a land, a road, which was the means of their ingress and egress. And there has been a shop or what? A liquor shop.
No. It's
But it says that there has been a hub of the liquor trade. That's why I asked.
No, it's a slum dweller.
They say, and they say that somebody has encroached upon this the land by dumping a garbage.
Well,
My lords, I am appearing on behalf of respondent number 6, who was the writ petitioner.
let me
So this is what they say. And the court has said that anything which has encroached upon the land, I mean the means of access, that is a pathway or a road, I do not. It says that you remove.
My lord, without granting opportunity, my lord, within 10 days.
Well, if you are right, the right to life is given to one, then it is.
My lord, what?
It does not give a unbridled right to another to impinge upon the right to life.
My lord, let me, my lord.
Under the garb of his right to life.
My lord, thing is that, my lord, the writ petitioner, my lord, misled the honorable single judge by saying that she has a residence over the land. But there is a vacant place, my lord.
Yes, is it the pathway which is being covered or?
No, my lord. That instruction I have given on 10/8/25. I have enclosed that instruction. If the lordship may kindly have a glance with that. Last occasion I had given that instruction.
Is not included.
Now, the present appellants, they have been issued with the land rights certificate by the Jaleshwar municipality. And so far as the Tahsildar is concerned, he has initiated encroachment proceeding against these petitioners.
Yes.
Now, so far as the obstruction that is alleged by the petitioner before the single judge, in fact, there is no obstruction that we have specifically stated. And that land.
It is a free access.
Yes, ma'am. Your lordship may kindly see.
Is there any accumulation of a garbage on the pathway?
That they have not.
Is there anybody who is creating a nuisance?
No, ma'am, that is
by,
not
by consuming liquor on the open road.
That is not in the.
Because she said that she is a, I do not know, septuagenarian or octogenarian. What?
Octogenarian.
Octogenarian, and lost the son and the husband both.
Both are.
So lordship will look at para 7 and 8 of that instruction.
So remove them.
So lordship may kindly for a moment. 7 and 8. Para 7 and 8. The land of Mr. Mrs. Kiranwala Patra, that is the petitioner before the single judge, which is in dispute pertains to khata number, plot number, so and so. That does not have any building or construction over the property. Then 8. Further, the scheduled land referred in point number 5 has 2 access points for ingress and outgress having width 30 feet respectively to her property, which is without any encroachment. And
My lords, may I please submit, my lords? There is an encroachment case and the honorable single judge, the case is still pending.
Encroachment case will take its own course.
My lord.
This interim order that the encroacher should totally out in front of the house, that is what at the interim stage came the court.
And that was the main prayer in the
hearing
rectification.
the other side, because they have actually accrued a right. Under that, what is this act where the encroachment proceedings are initiated?
What is the prevention of land encroachment?
That is what. So that law, they have initiated a proceeding. How the court can direct the eviction?
But this was submitted before the court that they have initiated the proceedings and they are yet to
Then
further
how can this
details.
order be passed in this nature? That they can be evicted, removed, and the proceeding will continue without any order of the competent authority. Can anybody be dispossessed without the due process of law? Can't be.
The proceeding is.
I'm not saying, but there is a common perception that the first principles of law, that the position is a 9th principle of right. How can one be thrown out in this way? And there is already, they will take care of that. And if there is any kind of hindrances put to your ingress and egress, they will definitely take care of this.
But the complaint was
And where is
regarding
your
that.
house? But somebody can go for what is the nature of the
Site
land?
inspection.
Which he is having.
It's an open place.
The nature of the land.
It's a CORAM, homestead.
Homestead. It's a homestead.
Homestead. Now, he must have constructed the kacha structure.
There is no construction. That is what the instruction says.
The permission or a sanction is required for making a power construction. If it is a thatched roof of a mud, does it require?
But her land has no construction, whereas the surrounding government land, there the encroachers have, the appellants have encroached.
Where is your structure?
Inside the boundary, the construction is inside the structure is in the boundary. the complaint or the petition mostly states that ingress and egress is being
I
hindered.
understand. He says that when you do not have the structure, how you can't live under the sky.
To enter the land, she is facing the problem.
No, that is I understand. That is I understand. Then the land, what you are doing, and there is nothing. If you are residing, I can understand. If it is an agricultural land, I can understand that every day you are doing mission offices. But if it is a homestead land, can't be utilized for any other purpose, except for the purpose of residence.
Even if she intends to raise a construction, she is being obstructed.
What if there is, or you are making a case at the bar? What case you have made out if you have Can a lawyer argue a fact which is not pleaded? Not. But anyhow, you can't do it, whatever. She has a right over them. But she has every right to have the ingress and egress to her property.
It is there, it is
Whether
available.
it's structure or no structure.
Yes.
If there is any obstacles or hindrances put while going to the property and coming out of the property, then second.
But para 8 of the instruction says that there is absolutely no obstruction for her to go to the property. That is what the instruction says. Para 8 of the instruction, if you are
So what is the stage of the encroachment proceeding?
only encroachment cases have been initiated in 2022-23.
So how many years will it take to reach its final destination?
That is not there.
Another 5-10 years.
Should not have.
22, it is instituted. 3 years has already elapsed.
Status, I will produce it if my lords wants to produce that status. What has happened to the encroachment?
Yes, we are granting you a leave, as you are. So it will not stay the operation.
My lord, one thing I can
Because
attention
because
to one
my own judgment is staring at you.
My lord, one particular thing I want to draw your lordship attention.
You go there, that's why, but that is my judgment in Manavasa Devi case. There, I have heard that the appellate court should not stay the operation of the interlocutory order at the time of an admission of it. I hear that it amounts to allowing an appeal itself. Only in an extreme and extraordinary circumstances, nothing more than that.
That although we have not preferred any appeal, the lordship will look at page 14. We are under contempt. That is, your lordship may kindly see the consequential order which was passed.
It is you who have to
the instruction. The encroachment case is not
party. When you applied for a leave to file.
Mile.
That is the application.
IA number. IA number 3531. 3533.
You have applied for certified copy.
My lord, since we are not made parties before the my lord court, we have also filed on distancing elements of distancing.
So you will not be able to apply for
No,
certified
no,
copy. Nothing.
it's a pending case, man.
So. In a pending case.
Since we are not party, we will not be.
I do not think any person aggrieved me apply for the certificate with the lawyer. May not. I do not.
म्यूट कर दीजिए
What's up? Not that unless you are a partner. Always a lawyer is engaged and he makes an application that I want to prefer a certificate. Accepted and given to. Is on the public domain. Why he cannot? Yes, that cannot. That order he can upload. So far as the certified copy is concerned, then we have. There are many surprises that come to me. Is not party, but he has the right to appeal.
But since
So he engages a lawyer, the lawyer makes an application that I have been instructed to challenge this order and therefore supply me a certified copy.
No, we cannot demonstrate that we have applied, but my learned friend said that the office refused to accept that measure since we are not party and it's a paper.
No, an application has to be made. Refuse to accept me, let them reject, but the application will not be made or communication not be done.
I said you have not made attempts. My lord, I heard your lordship. Heard.
This is the decision one, sorry, I get 3.2.
Adoption. Regarding certificate copy. They are not giving it. Only the state and the original rules. Rule 15 says that is because this difficulty we are facing. They are not giving copies of any matter pending unless it is finally disposed of. Your Lordship may kindly see, though Rule 15 says I have to, if a stranger is not a party, I have to state the reason, but it is practically not given matter, though the rule says that.
Oh, that is what is there.
Madam.
He has to state the object for which the copy is required. So he has to say that I have been instructed to prefer an appeal.
But your Lordship, that is
against this order. Why? The Rule 15 takes care of that. I was really surprised.
But your Lordship,
in effect,
that is not
being implemented.
they are saying that if no stranger, unless the case is disposed of, you will not get any order, interim order or any petition, any objection, anything. That is there, but in the rules it is there. But practically, my lord, the difficulty we are facing not getting. That is a practical. What my learned father is saying.
No, the language is very clear.
My lord.
How can you deny? I do not know.
We are not getting. If the matter is pending, the stranger is not getting the copy of entry.
But I am still surprised by 16. Rule 16.
Passover, I think.
Why?
My lord, the reason is your lordship.
What reason? Next party had entry order of injunction is not the order which is capable of being implemented.
Yes, your lordship. When there is a
or an appellant or a petitioner after obtaining the order does not file a requisite. Unless somebody brought to the notice of the court that the requisite is not filed within a time frame. The other side has to suffer the order.
No, in the registry it will not be given. When there is a direction to me.
So why not an application for certified copy be not allowed?
Because I am not complying the court's order.
If the requisites are not filed, why not? It should be. Requisites have nothing to do with the certified copy.
When the Honorable Court is directing to take notice immediately to the opposite party not complying, I may take the order and utilize without filing the requisites. That is the reason your lordship this restriction has been put.
More. The next party entry order on junction can be passed. If we go by a strict rule of Order 13 and Rule 3, which says that within 24 hours the service has to be affected. The consequences is that if the service is not affected within 24 hours, then in that event, it is open to the court to vacate the entry. Now, the requisites are not filed, but the court is not apprised of the fact that it has not been filed. Interim order continues, not go away unless the court vacates. And then if anybody who has been communicated with this order through some other means, can he not apply for certificate copy?
That difficulty will be there.
Yes, 15.
My lord, I was afraid that they have filed the reply and I have gone through that. So it has to be withdrawn. There is nothing this phase.
Panchayat Act. They have come before minors with a small prayer. But there is a provision, namely
section 115(6) of the Orissa Gram Panchayat Act, which gives power to the collector to remove a Sarpanch in the event it is found on fact-finding inquiry that 3 consecutive meetings have not been held. And here I have nothing to submit an order passed by the Honorable Single Judge. My Lord, I would not have come but for the last line, it is there reflected in the Honorable Single Judge's order. My Lord, the appeal was filed. Subject matter of the appeal is revocation of the removal order. So that appeal, my Lord, that was dismissed. Against that, this opposite party Sarpanch came before this Honorable Court. This Honorable Court, under Annexure 1, page 21, passed the order that the appeal would be heard. And within 4 weeks, I would submit before your 4 weeks would not be sufficient. By now, there is no development in the appeal because it is heard by the minister. That is the your lordship knows. On 14th it was posted. 15th my lord minister went to Balangir to attend the flag ceremony there, independently. So what I beg to submit, my lord, I am prejudiced because of the insertion of the default clause. If the appeal is not heard within 4 weeks, my lord, removal would stand revoked. That is amounting to the fact as if the appeal is finally disposed of, appeal is done. My lord, now in the meantime, your lordship knows, my lord, 4 weeks, records are to be closed, parties are to attend on the fixed date here. This is the only thing.
Should be passed. I do not know. I have also seen in the last month, this preceding month. How can this be passed?
This one.
Without application of mind.
Without application of mind is from
the,
without application of mind is from the initial stage of this case. This is only paragraph 8, your lordship. There is paragraph 5 and 6. 115(6)(a) clearly says that if a Sarpanch fails to convene 3 meetings, subject to
disqualification.
Yes, sir. Subject to filing of the grievance petition, they also lodge a subsequent FIR beside a grievance petition, which under your lordship, my learned senior has not attached the order of the collector's order. Collector removed me from 115(6)(a). I came to this court and got an order from the Honorable Single Judge to file an appeal. I myself appeared. I appeared 6 times along with the client, and in that case, I got to the case was 115(6)(a) order for failing to convene 3 meetings was set aside, not ignored. Then pendency of criminal case was inserted. The prayer was for 115(6)(a), your lordship. It was a new development that 115(6)(a) got set aside, and then insertion of pendency of a criminal case got included, which I presented before this honorable judge. After that, this 115(6)(a) does not exist anymore. Now the clause shifts to your lordship section 25(1)(g) of the Orissa Gram Panchayat Act, which is clear in paragraph 5 and 6 of the order, your lordship. So they filed a grievance petition, also an FIR. I have appeared in both the cases. Even at the appellate authority in the secretariat, I was also going to present the case. So 115(6)(a) was set aside and 25(1)(g) was included. So what 25(1)(g) says? It says 2 ingredients. That if a person is convicted for more 6 months or more than that, then he will be removed or disqualified. And number two is that the crime that he has done must damage moral turpitude of the society. The same honorable single judge asked my learned senior what was the crime and what was the FIR was for. So my learned senior himself replied that he stole certain books from the Panchayat office. He lost certain books of the Panchayat office. Is that damaging moral turpitude, sir? So moral turpitude was not damaged. So 115(6)(a), I was arguing myself, I removed it. It's not ignored, sir. 115(6)(a) after scrutiny, as my learned senior has inserted all the necessary inquiries that has been made during this time. Order dated 13/3, order dated 30/7/2024. Sir, paragraph 5 and 6 may kindly be seen while I am presenting the case. So now 115(6)(a) is not there anymore. 25(1)(g) is there. 25(1)(g) has 2 things. Sir, whether I am convicted. I am not convicted, sir. I have only misplaced certain books from the Panchayat office. I am an elected representative. So they filed, and it's pertinent to mention that the grievance petition is filed by the losing candidate's relative. The result I had attached in Annexure 2 of the writ petition. And who is third is the relative of the person who has lodged the FIR, who has also lodged the grievance petition. So these things are taken. So in paragraph 4 and 5 of the order, all the judgments that are mentioned in the impugned order, it is well taken care of, and all. In fact, I am aggrieved by the order of the honorable single judge that I humbly pray before this honorable court that my prayer was to set aside on the ground that all the judgments that I mentioned, it should be set aside. I should be reinstated. Sir, my learned senior is saying that it's only 4 weeks that he will take to file for the appeal. Sir, I won the election fair and square in 2022. Immediately they filed a grievance petition. Since 2024, I have been removed. I have my elected representative easily. So since 12/9/2024 till 21st August 2025, I have been running around. So that is the reason that these things, all these aspects and the judgments, if those judgments, your lordship, will be expanded. For example,
What do you want? Now this judgment
My-
has come.
sir,
It says that if it is not heard within 4 weeks.
yes, sir. Sir, all the mischief that has been playing around by the losing candidates. That is the reason, Your Honorable, I was able to convince the learned single judge that since 12/9/2024, since the day I have been removed, till 21/9/10/2025, and I won an election. I won an election against. It is 25(1)(g) now. Sir, my lord will open for my lord to decide that whether losing some books from the office is a moral turpitude. Am I violating moral turpitude if I am convicted? I am not convicted for 6 months. I got anticipatory bail from this honorable court. That was also I was appearing. So if 25(1)(g) is the context, my lord will decide whether moral turpitude is there or not. Sir, moral turpitude, my lord will see in paragraph 5, I found a very nice judgment where moral turpitude, very nice, from the Honorable Apex Court, from paragraph 7, it has been defined very cleanly from paragraph 7 to next 4 pages that what kind of offenses are moral turpitude. POXO, NDPS, murder, sexual offenses, ED, CBI cases. So these are moral turpitude. And it is given via example from paragraph 7, 8, 9, 10, totally concluded. And the judgments that I have given from the Odisha High Court regarding 25(1)(g), it has set aside the order of the removal and reinstated me. So that is why I feel incomplete that the 4 weeks part that has been given.
Did you file your counter in the trial court?
Trial court?
Single bench trial.
Sir, I had filed the writ petition. Trial court was filed by my learned senior. Counter was filed by my learned senior. It was filed.
You have filed a writ petition.
I had filed the writ petition, Your Lordship. Got allowed on that basis that so many things from the losing. Your Lordship.
The issue is, it will also.
It's not about paragraph 8 only, sir.
Just 1 minute.
The issue is 100 people.
The issue is well known to us.
Plus,
both of you are appearing well known to us.
Plus, it is not the order that if in 4 weeks the matter will not be heard. It is that they have not used their mind.
Understood. Your, the certificate that you have been elected?
So, elected as a, in the Sarpanch election, my lord, the election result in the
Annexure 2.
in the WBC Annexure 2. Page 10 of the petition, the election result I have only 26/2/2022.
We have been directed to do the equal within the last 4 weeks. That is all, my lord. If my lords do not interfere, we are bound to carry out the direction of the law.
The
4 weeks time has been granted to us. My lord.
So 4 week time is sufficient for. Is it or is it not?
Look, what is the present status, my lord? That is something which is.
I have a small issue in this, my lord. What my learned senior and the opposite parties are doing, that they are pushing for a by-election. If this by-election happens, their purpose will be solved.
Well,
Because if they do the
probability has.
no, sir, I have won the election. I have been elected representative. So many people voted for me.
Not true. That is, you got the highest number of votes.
Now they want to, they are pushed to do a by-election. All these things will become infructuous. That is the main purpose. So I humbly want to defend that.
14th it could not be taken up of it. 9th it is postponed.
They have been given extension of 12 days, my lord, from 28th to 9th. And we didn't object also. It's okay.
So why you have come?
Lord, I have come for a small prayer. Well, as such, within 4 weeks, my lord, appeal cannot be heard. It was
Who are you? This is the, they
No,
are the authority.
we
to
lost
hear
the,
out.
we lost the, I worked with the other ward members, we lost the complaint before the authority.
Whatever that they will hear out the matter, why you are putting a spanner into it?
Well, because under Annexure 2, SP has conducted the inquiry. They have stolen the resolution book to indicate the fact.
Sir,
We are the
whether
ward
that
member.
was a part of the show cause notice or not, or a separate show cause notice was issued, or it was a combined show cause notice, everything has to be looked into by them. Because I find that there are two kinds of allegations are made. One is non-conducting, three by a Sarpanch that invites the disqualification. And second one is that there has been certain books of the panchayat has been stolen. The show cause notice has to be given either in two cases, whether it was a combined show cause notice or it was a show cause notice only on one. We have to ascertain, they will consider. So they have to do it. You have no right to put a spanner into it.
Except that we had lost the complaint that saying that it is not.
Was it a part of the show cause qualification? Was not a part of the show cause. Was it?
No, sir.
Or it was only on a 3 consecutive notices?
Only 115.6.
meeting.
Yes, sir. Only 115.6, sir. After all these inquiries, after that, I appeared as an appeal.
Now thereafter the criminal case was lost.
Yes, sir.
For that no show cause notice
No,
has
sir.
been
Nothing,
given.
nothing.
So criminal case will take its own course.
That will take its own course and
Yes,
no
sir.
show cause notice, and it has been only decided in the appeal referring to the criminal that is quashed by this honorable single judge and directed the issue is 150 days.
Correct. Only 3 meetings whether he had or not. That's the only issue. And the court has correctly done it.
Only
Then
because
you can't
that
go into the criminal.
if it is not
One
done,
last thing, section 25(1)(g) read with section 4 of the act also clearly shows state government may remove the Sarpanch if he is convicted for an offence involving moral
But it
turpitude.
has not been convicted.
Yes. Sir,
Mere filing or lodging an FIR does
his
not mean.
position was restored after this. His position. My prayer is that he was immediately reinstated as Sarpanch.
Whatever, we are not going into it, sir. You have not filed a we are not interfering with this ordinance. What more? It is the state who has to take the call,
Yes.
not him.
Yes.
The direction is not passed upon him. I'm talking about a provision for a repeal.
Section 1 to
It does not provide, even 133 does not provide.
106 also does not, two appeal provisions, it does not provide. And only review provision. Against 100 people, no appeal made.
Because 103
Yes,
is in a different situation.
Not provided.
Anyhow, the order was, the order of removal was challenged before the state.
The suspension shall be revoked. That part will stay.
I have not interfered with the order. I have not said anything, nor I am going to say anything.
Deeply obliged, man.
They have not said anything.
Deeply.
Yes.
Item number 29.
Petitioner has been suspended. Violation of the there is a rule 19 of the OCS CCA rule. It is the petitioner taking the concurrence from the lending authority. The borrowing authority has suspended. It is the violation of rule 19. Specifically, The petitioner was working while working.
Which order you are challenging, sir?
The Honorable Single Judge only.
I am asking you,
Yes.
you are challenging the 31st.
Only,
July order.
yes, my lord, annex of, that is high. That is the order, my lord, Honorable Single Judge. Only to issue notice and did not interfere in the interim order, my lord, because it's a substantial prejudice. The petitioner clearly that is the violation of that is Rule 19. If your lordship permit me, then I will read that the of the lending authority, the borrowing authority cannot suspend. And if done, that is the petitioner was in the deputation of foreign service, and the authority who had suspended, he is not that is the authority, disciplinary authority, man. And so this is the purely this is the violation. Your lordship see that the 19 Rule 19 the proviso says that is they without concurrence cannot do. So Honorable Single Judge did not interfere, only put up this matter. There is after there is 4 months, which will be my lord, and it is substantially prejudice. Even if there is a violation, it is admitted fact that.
The instrument arises from an order dated 31st. Review. Not application need not be filed.
Maybe
I do not
only
know
time,
this is
only
Korea.
time may be fixed because so your lordship give time.
All the brethren fraternity. Not, that's why we use the very language in
Yes.
other way.
And they cannot be listed, that's why.
No.
My lord, and they cannot.
I think the language which we have used conveys, don't
I apply.
Item number 30.
Right, please, Your Lord. Not on a very small prayer, my lord, the petitioner is there. Whether for an inadvertent mistake which has caused no loss to anyone, the petitioner can be punished. That is the only issue before your lordship.
What? Repeat.
My lord. For an inadvertent typographical mistake which has caused no loss to anyone, whether the petitioner can be punished, your lordship, that is the only question.
What is the punishment?
Punishment is 2 years debarment.
Punishment, sorry. It's not a service matter.
No, my lord, not a service matter. Your lordship may kindly.
Blacklisting.
My lord, that is
Blacklisting. That is the debarment.
Debarment for a period of 2 years. I could not participate in the tender process for a period of 2 years. Your lordship may kindly see. I'll not take. Yes, your lordship. I filed an IA for expeditious disposal that I do admit. And the matter, my lord may kindly. Here, only your lordship, I'll place it. Only 2 pages.
IA copy I didn't have. I didn't know.
That is for expeditious disposal. That is for expeditious disposal. I filed and
Let us decide that application first.
that your
Let us
lordship.
decide that application.
My lord, I have filed an IA, your lordship.
No, IA, then the copy is to be served.
Yes.
Let us give a opposition to the application. IA will consider it.
That is for disposal. It is
Whatever
there.
be, she has a right to.
On last occasion, my learned sister prayed for a time in spite of my strong objection.
What?
So I consider that this time at least she would give some relaxation to me to place the matter. 1 year already over, your lordship. That is the difficulty I am facing. Your lordship, I'll take only 5 minutes time.
I understand the device, how to get the matter out of time to be disposed of.
That your lordship, I have filed an IA.
Normal order I used to pass there was, let this application be heard along with the appeal.
No, my lord, the difficulty is.
No difficulty. You
I
pass
have-
this order, put the application and the petition will be heard together.
I pray, my lord. Your lordship may consider. I bow down, my lord. My learned sister has not got the copy of service on the government. But still then, your lordship, only.
Debarment is something.
Yes, madam.
Yes.
I didn't know what was the content there.
So it is
It's for
that this is the-
expedition.
What mistake you have committed?
My lord, my mistake is that, your lordship, I'm just briefly submitting, my lord. I have applied in the tender. That is the tender floated to supply kits. That is the testing kits.
Kits.
The Odisha police has floated this tender for supply of kits. Now, those kits, they will collect sample, earth sample, blood sample. Those kits used for scientific foreign test. They floated tender for supply of those items. Now, 5 of such items in huge quantity were to be supplied. And I was selected as the L1 bidder, your lordship. I supplied, your lordship, all the materials. It was accepted. All payments were released in my favor. No dispute in that. Now, your lordship, I have given the bank guarantees. In bank guarantees, after 2021, they developed a procedure of paperless bank guarantee. That is EPBG, electronic bank guarantee. Now, in EPBG, I have to apply to the bank and the bank has to issue it. It's paperless mode. There is no, because in paper, there is question of forgery, fraud more. So they have made it paperless. In 2021, they have introduced it. That is Indian Bank Association and NESL. NESL is a government portal. That is National E-Governance Services Limited, which works as a repository of all these EPBGs. That I have supplied. Now, after everything is over, they detected a mistake that instead of the unique number of Odisha Police, that is UIN number, I have inadvertently mentioned one of my director's PAN number. I have mentioned Odisha Police bank account.
UIN instead of UIN?
UIN of Odisha Police. In the EPBG, inadvertently, I have mentioned PAN number of one of my directors.
DIN number?
PAN number.
PAN number.
PAN number of one of my
Not
directors.
even a DIN number?
No.
I have mentioned the account's name of Odisha Police, payee Odisha Police, account number of Odisha Police.
But your physical bank guarantee
is not there.
Was subsisting as date of this electronic bank guarantee?
Yes, Your Lordship, my bank guarantee been valid till today. It covers
Physical one.
the original
The duration of the bank guarantee
is been valid today, though I have taken money 2 years before.
That is still continuing.
Still continuing, my lord. Your Lordship may kindly see the mistake I do admit. I have mentioned Odisha Police account. I have
What has
mentioned
happened?
thereafter, Your Lordship, after everything is over, they made a query to NESL, that is government. They made a query to NESL, that is National E-Governance Services Limited. NESL said,
Bank could have changed.
bank did that. NESL said to Odisha Police in a mail that you please request it to the bank. There might be some mistake. Odisha Police made a query to the bank. Bank said, mistake. We are immediately rectifying it and we are uploading corrected EPPGs. It is corrected, immediately uploaded, causing no loss to anyone, my lord. Thereafter, they say that since you have mentioned your PAN number of director instead of UIN number, you invite punishment as per the code of conduct and 2 years department, blacklisting. The result is that, my lord, since 5/8/2024, I am unable to participate in any tender process across the globe because they consider blacklisting as a clog on my reputation. And I was debarred. I am completely, Your Lordship, debarred.
What you were doing?
I used to supply kits.
24. The matter is pending.
My lord. And Your Lordship may kindly see the only letter, my lord, I will place.
Yes, what is the
That's the stand which we have taken in the counter, my lords, is that such misrepresentation amounts to violation under rule.
What misrepresentation? The bank guarantee, performance bank guarantee is issued by a bank. If the bank has committed a mistake by disclosing the particular PAN number of the director instead of UIN number, but the guarantee remains to your organization. They committed a mistake, bank accepted that mistake and rectified it. And the rectification has been done, the uploading is also there. It's an obligation of the bank to honor in case he has defaulted or done anything that you can invoke the bank guarantee. For that debarment,
That's the application.
he has not said anything at the time of procurement.
Well, it's the application for bank guarantee. He had specifically mentioned the PAN number of one of the directors, my lords.
Sir, whatever be the reason, the bank guarantee is by a guarantee given by a bank. To whom is also there that I am issuing a bank guarantee in your favor. If you invoke, I am liable to make this payment to you. Is it dependent upon a UIN, dependent upon a PAN number?
If I may refer to the bank guarantee, it refers to beneficiary or the government, my lords. The word beneficiary / the government is mentioned in the bank guarantee terms, my lords. And the application which was made, which is my learned
So the bank guarantee is not issued to be.
It's issued in my favor.
That's all.
Yes, ma'am.
What more?
It's issued in
For this fringe issues, are you not happy with the suppliers? Or there is another cherry picking in your mind? You wanted him to come and supply?
Well, it's only when we pointed out the wrong which was committed, thereafter it was
These
corrected.
are all the errors. It does not impinge upon the validity of the bank guarantee, nor it impinges upon the invocation thereof. If both are not impinged, then what form the bank guarantees are there? As a security in the event any default, you can invoke it. And it is an irrevocable bank guarantee.
My lord.
So, unless you release, the bank guarantee would continue.
Yes.
No. And it has been corrected. And the bank has committed a fault. Bank rectified its fault.
Well, it's that to that portion, I only say that the application itself mentioned the PAN number.
If they have done it
and they rectify subsequently, and it does not really affect any kind of a, the genuinity or the invocation of the bank guarantee, then how can it be done? Something, and the matter is pending since 24.
Annexure 3, page 23, bank's letter, annexure
No,
3.
I'm looking at the order that who was asking for an adjournment.
Yes.
I have come across with 4, all government.
Yes, yes, ma'am.
5th order, no adjournment is recorded. 6th order, nothing is recorded. 7th order is again, the government has taken. No. Whereas the judgment of the department has the effect of a civil death, those judgment of our from Orissa High Court also went to the Supreme Court. In one of the case, this Pana or something, what is this?
Panda infra. Panda infra.
My lord, I searched for a judgment I'm sorry, I could not get a judgment of our own on the High Court. But that's a very judgment applicable to my case, that is by the judgment of Honorable Rajasthan High Court. Only paragraph 12, wherein some judgments of the Honorable Supreme Court were referred.
Which is very 49, it should be 105, the particular sentence has come.
Yes.
2014, 9 SCC 105. Professional Security Service, Local Government of Institute of Data. Another judgment 2014, 14 SCC 731.
No, this is the Panda Infra.
Panda Infra, not
104 SSC.
These are the deaths and death penalty. That term particularly.
That's a problem also used there. The CORAM Pharmaceuticals of 2001 is also have used that.
14, 9 SCC 105. The CF compilation also I have the compilation. 14, 11 SCC 731. Sorry, 14 SCC 731.
Yes. Give that judgment because in this judgment we had no occasion to consider this. This aspect has not been considered. I think there is another judgment where we have considered it. But we have not considered on this. Sorry, but we are looking at another judgment. Give that a reference.
May not go.
Where is the reference? 2000?
No, 14. 9 SCC 105.
This 2014 19 SSC.
My lord, 105.
Gorkha Security Services.
My lord.
Better off.
my lords. The demarcation was only for the procurement process undertaken by Odisha police, not the entire state of Odisha.
Can we regard this for all time to come? Yes.
31.
Public interest litigation related to the irregularities in management of the district mineral fund trust of the Kendujhar district. Division Court District Mineral Fund Trust. Division Court by the order dated 2nd January 2025 directed the state level committee to conduct an inquiry report.
Yes, has it been conducted?
Yes, one pursuant to the direction of the Honorable Court, the state level inquiry committee was constituted under the chairmanship of the chief secretary.
Yes.
And subcommittees across the department where the fund has been sourced for further use. My lord. There are 12 departments, out of which 6 departments have already furnished their inquiry report to the state committee, and 5 more departments have to submit. So it will take some time so that the final state level committee will furnish a report for this honorable court.
Well,
Your lordship may grant us 4 weeks time so that we can produce everything.
yes.
They have filed IA number 93979 checking time.
No, that has become infructuous, my lord. That we had filed earlier.
In this head,
That period has already gone.
So it was a district mineral foundation. What is the foundation was created?
Created under the rules for development of the mining area.
Correct. Now the what is there? High power committee.
State level committee is prescribed under the statute rules.
Which one? Which committee?
State level committee. Which is chairman of the chief secretary. The rules I have annexed, and this court in the order also observed the rule 18B is the committee, functioning of the committee. Para 6 of the order, order 2nd January 2025.
I am looking at the second
Para
committee,
6.
I am unable to find.
Para 6 minute. Rule 80B of the rules constitution of the state level committee by the state government to monitor the review and function of the trust.
You were flagging an issue that they are not taking steps.
They are not taking steps. The irregularity committed, there is a mandatory procedure for functioning of the funds of the trust. They have ignored the same.
39, my lord, at least the losses condition may mention letter 39, my lord.
Yes, the matter was on board for last 3 occasions, but due to the paucity of time, it is not taken. I'm not saying, my lord, what can be done? Only my submission is a tender matter that in the month of October. So any convenient, I'll take only 10 minutes time, my lord. Tomorrow if possible, my lord. After lunch at 2 p.m. 10 minutes time I'll take.
Item 46
is a very different. My lord, Monday.
There are many broken bench.
My lord, Monday.
I have to sit.
Monday at 2 p.m. I'll take only 10 minutes time.
Monday, let us see.
Item 46, my lord, entry order to marketing. 46.
46. We on the other side.
State, my lord. They have not filed the counter.
Oh.
As for is gone. If there is an interim order, it has to.
Item 51, my lord, that is a case fixed to today with regard to suspension.